Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan. Sampurasun, selamat pagi dan salam sejahtera bagi kita semua. Perkenalkan, nama saya Tiara Safia, dan bersama rekan saya, Daryl Anafi. Pada kesempatan kali ini, kami akan menjadi Master of Ceremony dalam acara Opening Ceremony Parahyangan Legal Competition 2021. Kami juga akan menginformasikan bahwa kegiatan Opening Ceremony Parahyangan Legal Competition 2021 akan dibawakan dalam dua bahasa. Dan pada sesi ini, saya akan membawakan dengan bahasa Indonesia dan rekan saya Daryl menggunakan bahasa Inggris.
Good morning, ladies and gentlemen. My name is Daryl Anafi, and I'm here with my partner, Tiara Safia. We will be the Masters of Ceremony for the opening ceremony of Parahyangan Legal Competition 2021. We would like to kindly inform you that the opening ceremony of Parahyangan Legal Competition 2021 will be conducted in two languages. I will deliver the session in English and my partner Tiara in Indonesian.
Kami ingin memanjatkan puji dan syukur kehadirat Tuhan Yang Maha Kuasa, karena kita dapat berkumpul di sini secara virtual. Kami juga ingin mengucapkan terima kasih atas kehadiran dari perwakilan Office of the United Nations High Commissioner for Human Rights, perwakilan Komisi Nasional Hak Asasi Manusia, Rektor Universitas Katolik Parahyangan, Dekan Fakultas Hukum Universitas Katolik Parahyangan, seluruh wakil dekan beserta jajaran Fakultas Hukum Universitas Katolik Parahyangan, dan Ketua Himpunan Mahasiswa Program Studi Ilmu Hukum periode 2021.
We would like to express our gratitude and gratefulness for the attendance of the representative of the Office of the United Nations High Commissioner for Human Rights, the representative of the National Commission on Human Rights of Indonesia, the Rector of Parahyangan Catholic University, the Dean of the Faculty of Law of Parahyangan Catholic University, all Vice Deans of the Faculty of Law of Parahyangan Catholic University, and the Chairman of the Law Studies Student Association 2021.
Sebelumnya, kami ingin menceritakan sedikit mengenai Parahyangan Legal Competition 2021. Parahyangan Legal Competition merupakan acara perlombaan terbesar yang diselenggarakan oleh Fakultas Hukum Universitas Katolik Parahyangan, yang di dalamnya terdapat perlombaan debat tingkat sekolah menengah atas, debat tingkat universitas, dan lomba karya tulis ilmiah. Parahyangan Legal Competition merupakan perlombaan terbesar, dan tahun ini Parahyangan Legal Competition 2021 mengangkat tema penerapan Pancasila dalam mewujudkan bisnis dan investasi yang berpihak pada hak asasi manusia. Dan tahun ini merupakan pertama kalinya Parahyangan Legal Competition dilaksanakan secara online.
Parahyangan Legal Competition is the biggest competition event held by the Faculty of Law of Parahyangan Catholic University that includes high school debate, university debate, and the writing of scientific papers. The Parahyangan Legal Competition 2021 theme is Upholding Pancasila towards human rights-based businesses and investment environments. And this year, it will be the first time that the Parahyangan Legal Competition is held online.
Terima kasih. Kami sampaikan kepada Office of the United Nations High Commissioner for Human Rights dan Komisi Nasional Hak Asasi Manusia karena telah menjadi co-host pada acara Parahyangan Legal Competition 2021. Selain itu, kami juga turut mengucapkan terima kasih kepada Adnan Kelana Haryanto and Hermanto Lovem, Anggoini and Partners, dan PT Nutrifood Indonesia karena telah menjadi sponsor dalam acara Parahyangan Legal Competition 2021. Selain itu, kami juga ingin mengucapkan terima kasih kepada Ardan Radio, Hukum Online, dan Berita 1 yang telah menjadi media partner dalam acara Parahyangan Legal Competition 2021.
We would like to say thank you to the Office of the United Nations High Commissioner for Human Rights and the National Commission on Human Rights of Indonesia for becoming the co-host of Parahyangan Legal Competition 2021. In addition, we would like to express our deepest gratitude to Adnan Kelana Haryanto and Hermanto Law Firm, Anggraini and Partners, and Nutrifood Indonesia Limited Liability Company for being our sponsors in Parahyangan Legal Competition 2021. Also, we want to thank Ardan Radio, Hukum Online, and Berita Satu for becoming our media partners.
Kami juga akan menginformasikan bahwa pemenang dari lomba debat tingkat universitas dan lomba karya tulis ilmiah akan mendapatkan kesempatan untuk mengikuti program internship magang di Angreni and Partners. Selain itu, para peserta yang hadir di sini, kalian dapat menemukan referensi hukum praktis dalam Premium Stories yang menghadirkan ulasan isu, doktrin hingga jurisprudensi, dan putusan pengadilan penting dalam satu artikel yang komprehensif. Kalian bisa langsung berlangganan sekarang, hanya 42.000 per bulan. Segera kunjungi hukumonline.com/stories.
We would like to inform you that the winners of the University Debate Competition and the Scientific Writings Competition will have a chance to join an internship program in Angreni and Partners. Other than that, to all participants that have attended the Zoom meeting, they are able to find practical legal references in Premium Stories that present reviews of important issues, doctrines to jurisprudence, and court decisions in one comprehensive article by subscribing for a price of 42,000 rupiah a month at hukumonline.com/stories.
Sebelum membuka rangkaian acara pada pagi hari ini, alangkah baiknya kita memulai dengan memanjatkan doa. Maka, untuk pembacaan doa sendiri akan dipanjatkan oleh Saudara Geraldo Adrian Stanis, selaku Koordinator Bidang Acara Parahyangan Legal Competition 2021.
Before we start today's event, we would like to begin with a prayer that will be led by Geraldo Adrian Stanis, Coordinator of Events of Parahyangan Legal Competition 2021.
Kepada Saudara Geraldo, kami persilahkan untuk memimpin doa.
Good morning, ladies and gentlemen. Let us begin Parahyangan Legal Competition 2021 with a prayer. I will be leading in Catholic prayer. Please pray according to your respective religions and belief. Let us pray. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father in heaven, we praise and thank you for your presence. Because of your grace, we were all able to gather in this virtual room at Parahyangan Legal Competition 2021 this morning. We would like to thank you for your guidance as we were all able to prepare for this event throughout the past months. Dear Father, send us your Holy Spirit from the beginning till the closing Sunday of the event. May your presence be with us, and may this event run according to your will. Lord, this is our prayer to you, for you alone are the Holy One, you alone are the Lord, you alone are the highest Jesus Christ, with the Holy Spirit in the glory of God the Father. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
Terima kasih kepada Saudara Geraldo. Selanjutnya, kami akan memasuki rangkaian acara yang pertama, yaitu menyanyikan lagu Kebangsaan Indonesia Raya, dilanjutkan dengan himne Universitas Katolik Parahyangan, yang akan kami putar melalui penayangan video berikut. Para hadirin, dimohon untuk bersikap siap.
For our first session, we will sing the Indonesian National Anthem, Indonesia Raya, followed by the Parahyangan Catholic University hymn, which will be shown through the next video. May the participants please get ready.
Jadilah
Sebelum kita memasuki acara selanjutnya, kami akan menampilkan terlebih dahulu video after movie dari Parahyangan Legal Competition 2019, di mana pada saat itu Parahyangan Legal Competition dilaksanakan secara langsung dan offline di Universitas Katolik Parahyangan.
Before we head to the next session, we shall present to you all a video about Parahyangan Legal Competition 2019, where in that year, Parahyangan Legal Competition was held offline at Parahyangan Catholic University.
fasilitas yang ditawarkan dan juga pelayanan yang diberikan juga menurut saya benar-benar bagus sekali, karena dari mulai dari akomodasinya sendiri, hotelnya juga dekat dari kampusnya, dan juga tempat-tempatnya juga enak untuk melakukan persiapan-persiapan di mana kamarnya tenang dan tidak terganggu, dan EO-nya juga bisa saling tanggung jawab satu sama yang lain sehingga bisa saling mendukung juga ke depannya.
Lengkap. Yang paling salut untuk PLC 2019 itu masalah waktu, karena biasanya di lomba-lomba lain tuh entah ya karet kendor gitu, dan menurut kami PLC itu kayak salah satu kayak kompetisi yang pernah kita ikutin yang paling tepat waktu, dan bahkan lebih cepat dari schedule yang ditetapin. Jadi kita juga sebagai peserta punya waktu buat persiapin segala hal lainnya, baik yang berhubungan lomba, terus settle untuk di akomodasinya lagi gitu. Jadi kita sangat support, kita sangat bangga, kita bersyukur bisa ikut PLC 2019.
Panitianya hits, LO-nya juga hits, lawannya juga hits.
Pokoknya ramai banget.
Setelah menyaksikan tayangan video Parahyangan Legal Competition 2019, selanjutnya kami akan menayangkan video Parahyangan Legal Competition 2021. Para hadirin, kami persilakan untuk menyaksikan tayangan video berikut.
After witnessing the video about Parahyangan Legal Competition 2019, we would like to present a video to our esteemed guests about Parahyangan Legal Competition 2021. Ladies and gentlemen, here is the following video.
Selanjutnya, kepada hadirin sekalian, perkenankan kami untuk menyambut para delegasi. Berikut adalah sekolah menengah atas dan universitas yang akan berkompetisi dalam Parahyangan Legal Competition 2021.
Next, allow us to introduce the delegations of the competition. The following are the high schools and universities that are competing in Parahyangan Legal Competition 2021.
Universitas Ahmad Dahlan, Universitas Erlangga, Universitas Andalas, Universitas Atma Jaya, Universitas Mataram, Universitas Maranatha, Universitas Gajah Mada, Universitas Indonesia, Universitas Islam Indonesia, Universitas Dharma Cendika, Universitas Brawijaya, Universitas Diponegoro, Universitas Islam Bandung, Universitas Jenderal Sudirman, Universitas Kristen Indonesia, Universitas Islam Negeri Syarif Hidayatullah Jakarta, Universitas Pajajaran, Universitas Pelita Harapan, Universitas Tarumanagara, Universitas Jember, Universitas Tanjung Pura, Universitas Pancasila, Universitas Syiah Kuala, Universitas 11 Maret, SMAK 1 BPK Penabur Bandung, SMAK 2 BPK Penabur Bandung, SMAK BPK Penabur Gading Serpong, SMA Talenta, SMAN 3 Merangin Jambi, SMA Indosemen, SMA Santa Maria 1 Bandung, SMA Santa Angela Bandung, SMAK BPK Penabur Tangerang, SMAK Santo Hendrikus Surabaya, SMA Kristen Yahya Bandung, SMA Negeri 1 Bandung, SMA Negeri 1 Garut, SMA Negeri 2 Garut, SMA Negeri 2 Tangerang Selatan, SMA Negeri 4 Denpasar, kepada seluruh sekolah menengah atas dan universitas yang akan berkompetisi dalam Parahyangan Legal Competition 2021, kami ucapkan selamat bertanding dan semoga sukses.
To all the high schools and universities competing in Parahyangan Legal Competition 2021, we would like to wish you all the best of luck in this competition.
Selanjutnya, kita akan mendengarkan kata sambutan yang akan disampaikan oleh Ketua Pelaksana Parahyangan Legal Competition 2021, Syifa Safira Al-Kafilah, melalui penayangan video berikut.
Next, we will be listening to a welcoming remark by the Chief Executive of Parahyangan Legal Competition 2021, Syifa Safira Al-Kafilah, which will be shown through the next video.
Hello, good morning ladies and gentlemen. Before I say something on this greeting, I would like to thank first to the MC that has given me a time to welcome as Chief Executive of Parahyangan Legal Competition 2021. Thank you to each and every one of you for being here today at this event, especially for our Rector, Mr. Mengadar Situmorang, our Dean, Mr. Leona Nanang Supriyatna, and our co-host, Office of the United Nations High Commissioner for Human Rights and National Commission on Human Rights, who have supported and assisted the entire PLC event. And our sponsors, Adnan Kelana Haryanto and Hermanto Lovem, also NutriFood, and media partner, Hukum Online, Berita Satu, and Ardent Radio. And I want to say thank you to the All Committee PLC who work hard to help organize this event. PLC is usually held offline at Parahyangan Catholic University. But due to this pandemic, this year's PLC is held online. However, this doesn't prevent us from continuing to organize this event as well as possible. Therefore, I would like to thank the participants for their enthusiasm, and I hope that we are all in a good health and well-being. This event was initiated from thoughts of Professor Dr. Bernard Arif Sidarta and Professor Mr. Sudiman Kartohadi Projo as Professor of the Faculty of Law, Parahyangan Catholic University. Therefore, we, as the pillars of the nation, have an obligation to raise awareness of Pancasila, and also we, as a Gen Z, have critical thinking about the existing legal issues. This year's theme is Upholding Pancasila towards a human rights-based business and investment environment in Indonesia. Indonesia is currently being confronted with the implementation of free trade, which includes doing business and investing. So, there needs to be a balance between the basic values of Pancasila and international legal instrument in doing business and investing for the realization of public welfare. For that, I welcome and congratulate all participants of Parahyangan Legal Competition 2021. Hopefully, we can work well together until the end of the event, and with all the knowledge, skills, and values in the event, can provide positive things in the future. Thank you and goodbye.
Selanjutnya, kata sambutan akan disampaikan oleh Pasha Sulaiman Kesumanegara, selaku Ketua Mahimpunan Mahasiswa Program Studi Ilmu Hukum periode 2021, yang akan disampaikan melalui penayangan video berikut.
Next, there will be a welcoming remark by the Chairman of the Law Studies Student Association 2021, Pasha Sulaiman Kesumanegara, which will be shown through the next video.
Assalamualaikum warahmatullahi wabarakatuh, and good morning to all the participants, judges, and committees of the Parahyangan Legal Competition event. First of all, I would like to introduce myself as one of the people who are going to give the opening speech. My name is Pasha Sulaiman Kesumanegara as the President of the Law Student Association from the Parahyangan Catholic University, and it is such an honor for me to speak on behalf of the organizer by saying welcome to the Parahyangan Legal Competition, or PLC in short. Before we start, I would like to express my warm regards to the Office of the High Commissioner for Human Rights, or OHCHR, and also Komisi Nasional Hak Asasi Manusia, or Komnas HAM. Thank you for supporting the Parahyangan Legal Competition event by further developing the extent of the critical thinking based on the human rights problem that are currently happening or has happened around the globe. We also want to thank and appreciate our generous sponsors, which comes from the Adnan Kelana Haryanto and Harmanto Law Firm, or AKHH Law Firm in short, Anggraini and Partners Law Firm, and also PT Nutrifood Indonesia. We have been very helped throughout the entire event, and we hope this good relation between the education institution and the sponsors can last for years ahead. Last but not least, we also want to thank our media partner, which includes Berita Satu Newscast, Hukum Online, and Ardent Radio for publishing our event. We hope our event has reached many people throughout Indonesia and has brought positive impacts for their lives. Today is a very special day for the law faculty of the Parahyangan Catholic University, because in this beautiful day, we have been given the opportunity to hold one of the biggest and prestigious law competition in Indonesia. Parahyangan Legal Competition has thrived successfully for the last couple of years, reaching more than 30 universities and high schools to participate in the event. Law debate and scientific writing has been our branch of competitions, developing not only the participants' skill of public speaking, but also writing. In that sense, I hope the people in this event can enjoy and participate in this event contently, and may the best team or people win. Thank you.
Selanjutnya, kata sambutan akan disampaikan secara langsung oleh Bapak Dr. Yuliana Nanang Supriyatna, SHM Hum, selaku Dekan Fakultas Hukum Universitas Katolik Parahyangan.
Next, another welcoming remark by Mr. Dr. Yuliana Nanang Supriyatna, Bachelor of Law, Master of Humanities, the Dean of the Faculty of Law of Parahyangan Catholic University.
Kepada Bapak Liona, kami persilahkan.
Ya, thank you Tiara and Rani ya. Oke, thank you. Assalamualaikum warahmatullahi wabarakatuh. Shalom, salam sejahtera bagi kita semua. Om Swastiastu, Namo Buddhaya, salam kebajikan, Sampurasun. To our esteemed guests, Ibu Profesor Anita Ramasastry from University of Washington as a keynote speaker and member of the UN Working Group. Bapak Ahmad Taufan Damanik, Chairman of KOMNAS HAM, Ibu Sandrayati Moniaga, Commissioner of KOMNAS HAM, Bapak Eko Riyadi, Director of Center for Law and Human Rights National Commission on Violence Against Women, Bapak Roberto Eugenio Cadiz, Commissioner on Human Rights Republic of Philippines, Mabuhay, Ibu Katia Chirizzi from OHCHR, Deputy Regional Representative, Ibu Sifani Verma from UNDP, Indonesia Business and Human Rights Specialist. On behalf of the Faculty of Law of Parahyangan Catholic University, I welcome all the participants, friends, and colleagues to the Parahyangan Legal Competition, or PLC, in this very fine morning. PLC is one of the most important events that we hold every year, and we are very proud that this competition is now highly regarded as one of the most prestigious law competition in Indonesia. This year, the topic of the competition is upholding Pancasila towards human rights-based business and investment environment in Indonesia. This reflects one of the core values of our university, namely preferential option for the poor. The need for modern economic and industry might sometimes compromise the protection of the indigenous people, the environment, health and safety concern, and other interests. We are very excited to bring these issues and emphasize the role of human rights and Pancasila in providing the safeguard in this regard. All the best to all the participants who will tackle these difficult questions. We hope that you all can take these issues and your experience in this competition further in your academic and professional life. I also welcome and give great thank you to our co-host, the United Nations Office of the High Commissioner for Human Rights, Southeast Asia, and Komisi Nasional Hak Asasi Manusia, or KOMNAS HAM. Your tremendous support and generosity make this event possible, and we look forward to continue working with you to advance the cause of human rights in Indonesia. Many thanks also to our sponsors, AKHH Law Firm, Localate, yeah, as well as to our media partners, namely Hukum Online, Berita Satu, Ardan FM, and Jabar Bergerak, Zilenial. Finally, thank you very much to Vira, Hugo, the entire organizing committee. Ibu Ida Susanti, thank you for your support. And Mr. John Lumantobing, thank you very much, Maulite Godang, and the team of lecturers for the tireless work in preparing and holding this year's PLCs. I'm confident that the entire PLC events this weekend will be a success. God bless you all. We all stay safe and healthy. Thank you. And I would like to hand over the screen to the Master of Ceremony. Thank you very much.
Terima kasih banyak kepada Bapak Liona. Selanjutnya, kata sambutan akan disampaikan oleh Bapak Mangadar Situmorang PhD, Rektor Universitas Katolik Parahyangan, yang akan disampaikan melalui penayangan video berikut.
Next, another welcoming remark by Mr. Mangadar Situmorang PhD, the Rector of Parahyangan Catholic University, which will be shown through the next video.
Mangadar Situmorang, Director of Parahyangan Catholic University, I warmly greet you all, welcome you all, and wish you all in a very good health and good condition. I have the privilege to welcome you all in this prestigious event, Parahyangan Legal Competition PLC 2021. Thank you to the students, the organizer from Parahyangan Catholic University, the Faculty of Law. We thank you also, UN Human Rights Office of High Commissioner and Indonesian National Commission for Human Rights, KOMNAS HAM, for your support, for your contribution to make this competition happen today. This competition take the topics about Pancasila, its relation, its meaning, its significance in businesses and investment. Personally, I hope that you will share your ideas, your opinions, your values about our national ideology, especially in its relation in investment and to businesses. Wish you all the very best. Thank you.
Selanjutnya, kata sambutan akan disampaikan secara langsung oleh co-host yang membantu terwujudnya dan terlaksananya Parahyangan Legal Competition 2021, yaitu Office of the United Nations High Commissioner for Human Rights, yang akan disampaikan oleh perwakilannya, Ms. Katia Chirizzi.
Next, a welcoming remark from our co-host that has helped the realization of Parahyangan Legal Competition 2021. Office of the United Nations High Commissioner for Human Rights, with its representative, Ms. Katia Chirizzi. To Ms. Katia, we invite you to say a welcoming remark.
Mohon maaf, kami akan melanjutkan dikarenakan adanya gangguan. Selanjutnya, kata sambutan juga akan disampaikan secara langsung oleh co-host selanjutnya, yang turut membantu terwujudnya dan terlaksananya Parahyangan Legal Competition 2021, yaitu Komisi Nasional Hak Asasi Manusia. Kata sambutan akan disampaikan oleh Bapak Ahmad Taufan Damanik melalui tayangan video berikut.
Next, a welcome remark from another co-host that has helped the realization of Parahyangan Legal Competition 2021, the National Commission on Human Rights of Indonesia, with its representative, Mr. Ahmad Taufan Damanik, through the next video.
Good morning, ladies and gentlemen. Mr. Rector Parahyangan Catholic University, Mr. Mangadar Situmorang, PhD, Deputy Regional Representative, United Nations Office of High Commissioner of Human Rights, Ms. Katia Chirizzi, Chief of Parahyangan Legal Competition 2021, Ms. Siva Safira Al-Kafilah, all committee, resource persons, and participants. On behalf of Komnas HAM, I want to express my appreciation for Parahyangan Catholic University for still holding Parahyangan Legal Competition 2021 amid the COVID-19 pandemic. Komnas HAM has regularly participated as the co-host of the event because this event is in line with Komnas HAM mandate on education and promotion of human rights. Moreover, I always believe that collaboration between Parahyangan Catholic University, Komnas HAM, and the United Nations Office of the High Commissioner for Human Rights Office, Southeast Asia Regional Office, will catch attention and raise awareness on human rights for youth. As part of the series of activities of 2021 Parahyangan Legal Competitions, a webinar is conducted with a main theme upholding Pancasila toward human right-based business and investment environment in Indonesia. Business and human rights have gradually drawn attention and are considered as important discourse in developing states, especially on relation between corporation and efforts on environmental protection. Considering its importance, Komnas HAM has launched National Action Plan on Business and Human Rights in 2017 to support business and human rights discourse and implementation in Indonesia. It was not without coincidence that last month we have celebrated the 10th anniversary of UN Guiding Principle on Business and Human Rights that widely recognized as an international standard of responsible business conduct and provides a clear framework for preventing and remedying the negative impacts that business has on human rights. I'm very pleased to welcome all the participants of PLC and webinar today. The enthusiasm showed by the youth to try to understand more about human rights in general and business human rights in particular raised a glimpse of hope of a better future. 20 years or more, I expect that participants from PLC soon take part and engage in important areas of work that will reshape Indonesia, that upholding Pancasila and human rights in every aspect. Thank you.
Sebelum memasuki acara selanjutnya, kami ingin menginformasikan kepada hadirin sekalian bahwa Parahyangan Legal Competition merupakan salah satu bentuk penghormatan kepada dua guru besar Fakultas Hukum Universitas Katolik Parahyangan, yaitu almarhum Profesor Arif Benat Sidarta SH dan almarhum Profesor Mr. Sudiman Karto Hadiprojo.
Before heading into the next session, we would like to inform our esteemed guests that the Parahyangan Legal Competition is a form of memento for two professors of Parahyangan Catholic University Faculty of Law, the late Professor Arif Bernat Sidarta, Bachelor of Law, and the late Professor Mr. Sudiman Karto Hadiprojo.
Maka, untuk acara selanjutnya, terdapat video pengenalan profil Disertai juga dengan kata sambutan yang akan disampaikan oleh keluarga almarhum Profesor Arif Bernard Sidarta SH yang akan disampaikan oleh Ibu Lani Sidarta dan keluarga almarhum Profesor Mr. Sudiman Karto Hadiprojo yang akan disampaikan oleh Bapak Profesor Dr. Johannes Gunawan, SHLM, selaku salah satu guru besar Fakultas Hukum Universitas Katolik Parahyangan yang mewakili keluarga almarhum Profesor Mr. Sudiman Karto Hadiprojo. Hadirin sekalian, kami persilakan untuk menyaksikan tayangan video berikut.
For the next event, there will be remarks and introductions from the family of the late Mr. Professor Arif Bernard Sidarta, Bachelor of Law, which will be delivered by Mrs. Lani Sidarta, and the family of the late Mr. Professor Sudiman Karto Hadiprojo, which will be delivered by Professor Johannes Gunawan, Bachelor of Law, Master of Law, as one of the professors of the Faculty of Law of Parahyangan Catholic University, and also a family representative of the late Professor Mr. Sudiman Karto Hadiprojo. Ladies and gentlemen, we invite you to watch the following video.
Bapak Rektor, Bapak Dekan Fakultas Hukum, Ketua Himpunan Mahasiswa Program Studi Ilmu Hukum, Ketua Pelaksana Parahyangan Legal Competition 2021, para undangan dan para peserta yang saya hormati. Profesor Mr. Sudiman Karto Hadiprojo tidak dapat dipisahkan dari perkembangan ilmu hukum di Indonesia. Sehingga Piala Parahyangan Legal Competition pun menyandang nama besar beliau. Sudiman lahir di Tuban, Jawa Timur 3 September 1908 dan wafat di Bandung 26 Januari 1970, dimakamkan di Taman Makam Pahlawan Cikutra, Bandung. Lulus dari HBS pada tahun 1927, ia melanjutkan ke Sekolah Tinggi Kedokteran di Batavia. Sudiman merasa menjadi dokter bukan panggilan jiwanya. Karena itu, ia pindah ke Rechtshogeschool atau Sekolah Tinggi Hukum yang diselesaikan pada tahun 1936 dengan gelar Meester in the Rechten. Beliau adalah akademisi hukum yang pernah berprofesi sebagai hakim, jaksa, dan pengacara. Di dunia pendidikan tinggi hukum, beliau adalah guru besar Fakultas Hukum Universitas Indonesia dan salah satu pendiri dari Akademi Hukum Militer serta dekan Fakultas Hukum UNPAR pada tahun 1961. Sudiman pernah menjadi guru besar tamu pada University of California, Berkeley di Amerika Serikat pada tahun 1957 sampai 1958. Kehidupan Sudiman mencerminkan watak orang yang sederhana, jujur, setia, dan adil. Akademisi yang memiliki keutuhan pribadi dengan keberanian moral menjunjung tinggi kebenaran dalam keadaan apapun. Beliau telah menulis sejumlah buku yang memuat pemikirannya yang jauh melampaui zamannya. Antara lain tentang yang pertama, 4 aspek manusia, yaitu raga, aspek psikomotorik, rasa, aspek afeksi, rasio, aspek kognitif, dan rukun, aspek kooperatif. Yang oleh UNESCO pada tahun 1998 bulan Oktober dideklarasikan sebagai learning to know atau rasio, learning to be atau rasa, learning to do atau raga, dan learning to live together atau rukun. Pemikiran beliau yang kedua adalah mengenai 2 faktor yang mempengaruhi corak hukum dalam suatu negara, yaitu politik hukum atau cara berpikir deduktif tentang turut campurnya negara melalui alat perlengkapan negara dalam hal pelaksanaan hukum, perkembangan hukum, dan penciptaan hukum. Faktor kedua adalah kesadaran hukum, yaitu cara berpikir induktif tentang perasaan keadilan dalam masyarakat. Pada masa kini, disebut sebagai metode penelitian hukum multi dan interdisipliner yang menggabungkan cara berpikir deduktif dan cara berpikir induktif. Demikianlah akhir kata, selamat berkompetisi. Semoga bermanfaat bagi pengembangan hukum dan ilmu hukum di Indonesia. Terima kasih.
Puji syukur kita panjatkan kepada Tuhan yang Maha Pengasih dan Penyayang bahwa kita dapat bertemu meski secara virtual. Semoga kita selalu dilimpahi kesehatan selama masa pandemi yang belum juga berakhir. Balance, seimbang, itulah yang dilakukan Pak Arief Sidarta dalam hidupnya. Menjaga keseimbangan dalam hidup yang dilakukan Pak Arief sebaiknya dapat kita teladani dalam hidup kita. Keseimbangan seperti apa? Dalam hidupnya Pak Arief menyeimbangkan karyanya sebagai dosen dengan peran sebagai anggota masyarakat. Sebagai dosen, Pak Arief menghabiskan waktu banyak untuk membaca dan menulis. Bisa seharian penuh mengurung diri di perpustakaan pribadinya untuk memaknai bahkan menemukan hukum. Tapi Pak Arief juga banyak aktivitas sosial, seperti aktif di Yayasan Boromius sejak tahun 1970 hingga menjelang saat berpulangnya. Boromius adalah rumah sakit, fasilitas masyarakat yang membantu warga Bandung menyembuhkan dan menyambung nyawa pasiennya. Puluhan tahun Pak Arief ikut memikirkan perkembangan rumah sakit Santo Boromius. Tentu saja semua ada masanya. Sebagai mahasiswa, mungkin belum saatnya dapat terlibat dalam peran besar seperti di sebuah yayasan. Tapi ada banyak cara untuk punya kontribusi di masyarakat. Para mahasiswa dapat membantu warga yang sekarang kesusahan akibat pandemi COVID-19. Dapat saja misalnya jadi relawan di LBH untuk mendampingi para buruh yang di PHK untuk mendapatkan hak-haknya. Tugas mahasiswa jelas belajar, namun andai saja bisa membantu sesama, itu nilai plus. Itu membuat hidup adik-adik lebih balance dan juga lebih berwarna, seperti yang dijalankan Pak Arif dalam hidupnya. Terima kasih. Semoga dari hari ke hari kita lebih baik dalam mengarungi kehidupan ini. Selamat dan sukses atas penyelenggaraan PLC 2021.
Kemudian, acara akan dilanjutkan dengan pengembalian dan pengenalan piala bergilir lomba debat sekolah menengah atas, universitas, dan lomba karya tulis ilmiah, di mana piala tersebut merupakan bentuk penghormatan kepada almarhum Profesor Arif Bena Sidarta SH, dan almarhum Profesor Mr. Sudiman Karto Hadiprojo.
Next, the event shall be continued with the returning and introduction of the trophies for the high school debate, university debate, and the scientific writing competitions. The trophies are a tribute to the late Professor Arif bin Sidarta Bachelor of Law and the late Professor Mr. Sudiman Karto Hadiprojo.
Kesan untuk lomba tahun lalu tuh seru, tema-temanya juga menarik, asik untuk di breakdown, hadiahnya juga menarik. Kalau untuk pesannya untuk yang tahun ini berlomba, semangat buat breakdown satu-satu tema yang dikasih, buat nganalisis, buat riset, dan semangat juga buat latihannya. Semoga hasilnya sesuai dengan yang diharapkan.
Halo semuanya, kenalin kita dari Universitas Erlangga. Aku Ezra Tambunan.
Aku Ordana Kristiano Ventri.
Ya, jadi di sini kita adalah peserta PLC atau Parahyangan Legal Competition tahun 2020. Mungkin di sini kita mau kasih kesan pesan kita terhadap Parahyangan Legal Competition itu sendiri. Kalau buat aku sendiri, kesan dari aku pribadi sama Ventri juga, mungkin karena Parahyangan Legal Competition itu merupakan lomba yang salah satunya merupakan lomba yang sangat prestis bagi kami. Kenapa Parahyangan Legal Competition itu merupakan lomba yang sangat prestis bagi kami? Karena sebelumnya pada penyelenggaraan atau tahun pertama itu sendiri di tahun 2010 itu UNER itu sendiri menjadi juara 1 di lomba Parahyangan Legal Competition.
Ya.
Itulah mengapa pada tahun 2020 ini kemudian kami benar-benar sangat tidak menyangka gitu ya untuk memenangkan juara pertama di Parahyangan Legal Competition tahun 2020 kemarin.
Ya, dan untuk pesannya ketika melihat kemarin bagaimana pengalaman kami mengikuti kompetisi yang sangat luar biasa, baik dari panitia, juri, dan segala sesuatunya diatur sedemikian rupa sehingga menghasilkan satu kompetisi yang menurut saya sangat bergengsi. Maka harapan saya dan Ezra dan pastinya perwakilan dari UNER sendiri supaya Parahyangan Legal Competition tetap dapat menyelenggarakan kompetisi yang semakin berkualitas, semakin dapat menjaring debaters profesional di tingkat mahasiswa, dan pastinya teman-teman dari seluruh universitas di Indonesia jangan sampai melewatkan Parahyangan Legal Competition tahun 2021. Yang pasti harapan kami selalu yang terbaik untuk PLC 2021 ini.
Mungkin sekian dari kami, sampai jumpa.
Halo semuanya, perkenalkan saya Trian Maulana, perwakilan dari pemenang PLC tahun 2020 dari SMA Negeri 2 Garut. Di sini saya ingin menyampaikan kesan-pesan saya selama mengikuti PLC tahun 2020. Untuk kesan sendiri, saya merasa bahwa PLC ini menjadi suatu batu loncatan untuk saya dan teman saya untuk meningkatkan skills ataupun potensi yang ada di dalam diri kami. Maka dari itu, PLC sendiri adalah suatu momen dalam hidup saya yang tidak akan terlupakan. Kemudian, untuk acaranya sendiri, saya merasa bahwa PLC ini adalah suatu perlombaan yang sangat luar biasa. Dari mulai panitianya yang sangat luar biasa dalam mempersiapkan perlombaannya, juga dewan juri yang tidak kalah keren, serta para pesertanya juga yang sangat kompetitif, menjadikan PLC ini suatu perlombaan yang sangat sengit. Kemudian untuk pesannya sendiri, saya ingin menyampaikan kepada teman-teman semua peserta PLC tahun 2021 bahwa kemenangan bukanlah segalanya, namun menginginkan kemenangan itulah yang terpenting. Tidak ada kemenangan yang didapatkan dari hasil ataupun persiapan yang biasa saja. Maka dari itu, kita harus mempersiapkan diri kita dengan begitu luar biasa agar bisa tampil maksimal saat kita berlomba nantinya. Maka dari itu, di akhir kata saya ingin menyampaikan bahwa selamat berjuang kepada teman-teman semua peserta PLC tahun 2020. Semoga acaranya dapat berjalan dengan lancar dan juga PLC ini akan menjadi semakin lebih kompetitif. Demikian dan terima kasih.
Kemudian, acara akan dibuka secara resmi oleh Dekan Fakultas Hukum Universitas Katolik Parahyangan, Bapak Dr. Eugenio Supriyatna, SHM.
Now, the Parahyangan Legal Competition 2021 shall be officially started by the Dean of the Faculty of Law of Parahyangan Catholic University, Mr. Dr. Eugenio Supriyatna, Bachelor of Law, Masters of Humanities.
Thank you, Tiara and Daryl. I hereby declare the Parahyangan Legal Competition 2021 has officially started. Thank you.
Terima kasih banyak kepada Bapak Liona. Memasuki acara selanjutnya pada pagi hari ini, yaitu webinar yang akan mengangkat tema penyelenggaraan bisnis yang berbasis hak asasi manusia. Dalam sesi ini, webinar akan dibawakan secara penuh menggunakan bahasa Inggris. Mengingat webinar dibuka secara umum, maka kita akan menunggu beberapa saat untuk mobilisasi partisipan umum ke dalam ruangan Zoom.
For the next session this morning, we will be conducting a webinar with the topic of human rights-based business operations. This session will be fully conducted in English. Before heading to the next session, we shall wait for all public participants to join the current Zoom meeting.
personal story of coming to Australia as a refugee, and I share the story of arriving into a community that is very diverse and welcomed me with open arms. And I share that story because I want to show people what kind of community we could be if we welcomed everyone who arrived in our community and in and amongst us. We could be more diverse, we could be stronger together.
One thing we do need to avoid is stories of violence, stories of hate, because stories of positivity teach us all to work together to be able to reflect better on the things that are common to us and that we all believe in.
We think it's really important to combat hate speech with more speech. So it's really important for us to promote a pluralistic media environment.
Mobilizing consumers to speak to the companies that they shop with and encourage those companies to advertise more responsibly and avoid advertising with media that fuel hatred.
I think all around us we see migrant communities often, and I think it's important that we have those conversations with those communities, and I think that at the end of the day, I think develops and grows a much more inclusive society for all of us.
This message that we have more in common than what divides us is remarkably powerful. You can sometimes hear it and think, well, come on, that's kind of obvious. But actually, it's not what people are hearing every day. What they're hearing every day is change, difference, the threat of the other. And they need reminding that, in fact, as people, most of us, most of the time, have the same hopes, the same aspirations, and that we do have much more in common than what divides us.
Apa itu hak asasi manusia? Hak asasi manusia adalah hak yang melekat pada manusia sebagai anugerah Tuhan yang wajib dihormati, dijunjung tinggi, dan dilindungi oleh negara, hukum, dan semua orang. Secara umum, HAM bersifat kodrati, yang artinya HAM adalah hak yang telah menjadi kodrat manusia. Selain itu, HAM bersifat universal, yang artinya HAM secara umum berlaku di seluruh dunia dengan tetap menghormati adat istiadat dan budaya negara masing-masing. HAM juga bersifat langgeng, yang artinya HAM adalah hak manusia sejak dari dikandungan hingga meninggal. Manusia memiliki hak yang tidak dapat dikurangi dalam keadaan apapun, yaitu hak untuk hidup, hak untuk tidak disiksa, hak kemerdekaan pikiran dan hati nurani, hak beragama, hak untuk tidak diperbudak, hak untuk diakui sebagai pribadi di hadapan hukum, dan hak untuk tidak dituntut atas dasar hukum yang berlaku surut. Hak-hak itu adalah hak yang tidak dapat dikurangi dalam keadaan apapun. Namun tidak semua HAM dapat dikurangi, ada juga hak-hak yang dibatasi. Hak seseorang dapat dibatasi oleh undang-undang, misalnya, setiap orang berhak untuk memiliki dan membangun tempat tinggal. Namun orang lain tidak berhak mengganggu atau menggusur tempat tinggal orang lain sewenang-wenang, walaupun itu untuk membangun tempat tinggalnya sendiri. Atau pemerintah tidak berhak sewenang-wenang menggusur tempat tinggal orang lain tanpa menjalani prosedur. Untuk menjamin hak asasi manusia, negara dan pemerintah wajib untuk melindungi, memajukan, menegakkan, dan memenuhi hak asasi manusia. Negara dan setiap orang wajib untuk menghormati HAM. Artinya, tidak boleh melakukan tindakan atau mengganggu HAM orang lain. Misalnya, masyarakat yang sudah menikmati haknya untuk beribadah secara bebas tidak boleh diganggu. Negara berkewajiban untuk melindungi HAM. Artinya, ketika ada pihak lain yang mengganggu HAM, negara wajib memberikan perlindungan. Contohnya, ada orang yang sedang menyampaikan haknya untuk berekspresi, lantas ada pihak lain yang mengganggu. Maka negara, misalnya polisi, harus melindungi orang yang sedang menyampaikan ekspresinya itu. Negara berkewajiban untuk memenuhi HAM. Artinya, negara harus mengambil langkah-langkah supaya setiap orang menikmati HAM secara lebih baik dan meningkat dari waktu ke waktu. Contohnya, hak anak atas pendidikan. Maka, negara wajib menyediakan gedung sekolah yang layak, guru yang berkualitas, dan materi pelajaran yang bermutu baik. Selain itu, setiap orang wajib menghormati hak asasi orang lain dan tertib di dalam kegiatan bermasyarakat. Namun dalam menjalankan hak dan kebebasannya, setiap orang wajib tunduk kepada pembatasan yang telah ditetapkan undang-undang agar dapat menghormati hak dan kebebasan orang lain. Apabila seseorang atau sekelompok orang atau aparatur negara dengan sengaja atau tidak sengaja mengurangi, menghalangi, membatasi, atau mencabut HAM orang lain, maka hal tersebut adalah pelanggaran terhadap hak asasi manusia. Pelanggaran hak asasi manusia akan menjadi akar dari segala permasalahan dari suatu negara. Mari kita ciptakan dunia tanpa kekerasan dan diskriminasi, saling menghormati dan menghargai sesama manusia. HAM untuk semua. Laporkan setiap bentuk pelanggaran HAM, jangan diam.
Before we jump to the webinar session, we would like to inform you with the webinar rules.
For the first rules of the webinar, participants must join 30 minutes before the event starts to re-register participation by the host. The delay in admitting participants to enter the webinar room due to the mistake of not entering 30 minutes before the webinar starts will not be the responsibility of the committee.
Second, participants are required to join the Zoom room using register name and email.
Third, participants that have registered and received the Zoom link provided by the committee are prohibited to share the link.
During the webinar, participants are required to turn on their camera and mute their microphone, unless permitted by the moderator. If the participants have been reminded and still activate their microphone, they will be removed by the host from the Zoom room.
The host has the right to remove participants who are A, using harsh words or anything associated with SARA, B, doing activities that can interfere with the webinar, and C, not complying with the existing regulations. The participants who have been removed will automatically be unable to re-enter the Zoom room. During the photo-taking session, participants must activate their cameras.
Participants are expected to stay in the Zoom room during the event, unless there are technical difficulties. During the question and answer session, the question format that must be written in the Zoom chat for those who wanted to ask a question will be, "My name is blah blah blah. I want to ask Mr. Mrs. blah blah blah, and my question is blah blah blah." For example, "My name is Putri. I want to ask Mr. X, and my question is, why does business management have to pay attention to human rights aspects?"
Then, the moderator will determine the approved questions from the participants who have asked in the Zoom chat.
The committee will distribute the webinar material and a link to fill in the participants' attendance after the webinar has ended. If participants have further questions, please contact Rahma Kusunu Madinah or her phone number 0822084136.
Those are the rules regarding the webinar session. We would like to inform all participants to fill in the re-registration form link that will be announced by the committee through WhatsApp groups and the Zoom chat at the end of this webinar. This is required for all participants as we will need the data to hand out certificates of participation.
Ladies and gentlemen, for the first webinar session, there will be 2 keynote speeches. The first speech will be brought by Ms. Anita Ramasastry as the first keynote speaker. We would like to proudly present you the curriculum vitae from our first keynote speaker. Professor Anita Ramasastry is a professor of law from the University of Washington. Recently, she has been posted as the Director of Sustainable International Development Graduate Program and the Faculty Director on International, Comparative, and Transnational Programs. Her bachelor and doctoral degrees had been done in Harvard University, and her master's degree had been undertaken in the University of Sydney.
She is the Vice Chair and a member of the United Nations Working Group on Business and Human Rights. She has been appointed as an independent expert by the United Nations Human Rights Council to promote the effective and comprehensive dissemination and implementation of the guiding principles on business and human rights, that is, implementing the United Nations Protect, Respect, and Remedy framework. She also leads anti-corruption, development finance, business and conflict, and human rights defenders work. Ladies and gentlemen, we will begin the first keynote speech. We shall now hand the session over to Ms. Anita Ramasastry.
Distinguished panelists, colleagues, and participants, greetings from Seattle, Washington. I'm sorry I couldn't be with you in person today. I extend my thanks to the organizers for inviting me to make opening remarks today at this event focusing on business and human rights in Indonesia. I address you in my capacity as a member of the UN Working Group on Business and Human Rights. We are a group of 5 independent experts from different regions, including Asia. Indonesia holds a special place in my heart. I am a law professor at the University of Washington in Seattle. Over my many years of teaching, I've had the privilege of teaching many lawyers and students from Indonesia coming to Seattle to study sustainable development and business and human rights. Our Indonesian alumni are leading professors, researchers, and government officials, as well as senior lawyers in the private sector. Through working with them, I have come to learn and appreciate Indonesia's vibrancy and diversity, and its importance both within the region as well as globally as a member of the G20. As you know, the guiding principles are the UN-backed and only global framework on the respective duties and responsibilities of governments and business to prevent and address business-related human rights abuse. They are based on 3 pillars of the state duty to protect against abuse, the corporate responsibility to respect human rights, and the need for access to remedy for abuse that does happen. The working group submits reports to the Human Rights Council and the UN General Assembly each year, where we have, for example, addressed the need for greater policy coherence in government action, the role of states as economic actors themselves, key expectations for business-related human rights due diligence, the need for heightened state and business action in conflict-affected regions, the connection between business and human rights and corruption, and the gender dimension of business and human rights. We also promote development of national action plans on business and human rights, and we work closely with the High Commissioner for Human Rights, the ILO, the OECD, and UNDP, all of who are active in Indonesia. The working group conducts country visits to assess national efforts to implement the guiding principles, and we issue recommendations to governments, business actors, and civil society after those visits. Of course, the wider context to our discussion is the ongoing pandemic and its economic consequences, which are being felt in all regions, amplifying existing patterns of human rights abuse and inequalities in global markets. We have called on governments and businesses to ensure that their responses to the crisis are grounded in their international human rights duties and commitments. When building back, we need responsible business as a key ingredient of sustainable recovery and resilience for the future. This is the context in which we undertake the project of the next decade of the UN Guiding Principles. Just recently, on the 16th of June, we marked the 10th anniversary of the Guiding Principles and their unanimous endorsement by the UN Human Rights Council. The 10-year anniversary is not only an important milestone, it is a reminder of much of the work that remains unfinished and which you'll be discussing today in the national context. As part of our mandate to promote the principles, we decided to use that milestone as an opportunity to reflect on progress and challenges, but also more importantly, to make a renewed push for scaled-up global implementation of the guiding principles over the next decade, and to go from socialization of the guiding principles, just learning about business and human rights, to a decade of action. We therefore launched the project, the UN Guiding Principles 10 Plus, in July of last year. The project has 2 main components. The first one, which we just presented to the Human Rights Council, was a stock taking, to take stock of the first 10 years of implementation. This is a look back and includes assessing progress, gaps, and challenges, as well as obstacles and opportunities for advancing more robust policy action in the coming years. And then the second part, the stock taking, is going to be followed by a roadmap for the next decade, with the forward-looking recommendations for state actors and business, including investors, as well as other actors who have a role to play in promoting implementation of the guiding principles. This roadmap will be launched later this fall. We're also encouraging regions and even states to consider roadmaps in the local level because, of course, bringing the guiding principles into the local context is so very important. So thinking about a roadmap for the next decade in Indonesia will be very important. In terms of our stock taking or looking back, what did it reveal? It may be perhaps fitting to ask, what are the issues we didn't see in 2011? Obviously, we didn't see the pandemic coming, or at least fully realize how a pandemic could strike out the economy with the devastating impacts, especially on the most vulnerable people, even if WHO and health experts have been warning us for a long time. But beyond the pandemic, many of the fundamental challenges are still the same. In fact, the guiding principles and their 3 pillars were developed as the world was dealing with the consequences of the 2007 financial crisis. And yet much of that analysis still remains relevant today. So the guiding principles came out of an economic crisis, and so we can learn a lot from why it is an important framework and tool to help future-proof and help businesses to anticipate the harms that they may cause and to address them and mitigate them. Our current stock-taking comes at a time when the world is facing, however, a convergence of crises, ranging from the ongoing human and financial costs of COVID-19 to the climate crisis, to gross and growing inequality, to pervasive gender and racial discrimination, and also to shrinking civic space and to threats to human rights defenders globally, and the human consequences of technological developments from mass-scale surveillance to automation of work. This convergence of crises is more intensified today and highlights why our efforts are urgent. The guiding principles foresaw many of the key challenges that we still need to overcome. So this is where I talk about the gaps. Fundamentally, the governance gaps that created the need to develop the guiding principles still allow too many instances of business-related human rights abuses across all sectors and regions. We still have ineffective prevention by states and businesses, especially one that is based on adequate stakeholder engagement. So while we have greater adherence to the guiding principles, we don't have what we'd say the best in class engagement, which would be using rights holders and placing them, placing rights holders at the center and seeking their voices to determine where the harms are and how to prevent them. We need to overcome barriers to access to remedy for victims of business-related impacts, and this, of course, is perhaps the biggest gap. We need to provide remedy. That's why we have the guiding principles, yet we still are very far from that. We have lack of policy coherence in government and at a multilateral level, including in the context of what we call the state-business nexus, when states engage in procurement or other kinds of activities. Are they using that as a chance to require businesses to respect human rights? So in the domain of investment policy, public procurement, and the policies and practices of state-owned enterprises, we still don't see governments living up to their commitments. And finally, policy coherence in business practice is lacking, which ultimately undermines responsible business. Cases in point include companies committing to human rights, but not recognizing the role of unions in safeguarding human rights in the workplace. So having a strong policy saying we support the GPs, but then not supporting unions, or engaging in legal action against activists. In terms of progress, the UN Guiding Principles do provide a globally agreed upon standard and baseline for what governments and businesses need to do to embed business respect for human rights. This clarity and common platform for action didn't exist in 2011. We wouldn't be having this kind of a conference or discussion then. Perhaps the greatest contribution, the concept of corporate human rights due diligence from Pillar 2. Introduced by the Guiding Principles, it is now at the center of regulatory developments, with increasing backing from some business and investors. It has been taken up by a wider range of actors that influence and shape business, from civil society organizations to financial institutions, even to business and trade organizations. Now, the Guiding Principles clearly establish that states should not assume that businesses prefer or benefit from state inaction. They clarified that states should consider what we call a smart mix of measures, national and international, mandatory and voluntary, to foster business respect for human rights. We are seeing a hardening of the smart mix with the due diligence legislation coming in the EU, Germany, Netherlands, Norway, and already existing in France. We see this as a natural evolution of the normative development, but it naturally takes time and does not follow a straightforward line. Because of the potential for greater legal certainty, more level playing fields, and increased leverage within supply and value chains, this is because of a decade of experience with the Guiding Principles. And we see an increasing number of business voices that actually support mandatory human rights due diligence measures. In short, the focus in the past decade has shifted from if we need regulation to how to make mandatory requirements effective. And this should not be understated. These developments will need to be followed with greater attention to ensure meaningful due diligence aligned with the Guiding Principles. Now, let me acknowledge the major steps Indonesia has taken over the years in terms of business and human rights and responsible business conduct. First, Indonesia was one of the first countries to move in the prior decade to embed corporate social responsibility in its legal frameworks, including the company law. Indonesia's laws made it mandatory for companies in the natural resources sector to incorporate CSR into their activities. Indonesia has also been a leader in areas such as sustainable finance, with its Sustainable Finance Roadmap launched in 2014. More recently, of course, we note the work of LSAM and of the National Human Rights Commission to draft a National Action Plan on Business and Human Rights. While this was not an official state plan, this was an important step in highlighting the need for national action and focus on business and human rights as a policy priority. I'm pleased to learn that the Law and Human Rights Ministry has committed to the development of a national strategic plan on business and human rights that will focus on sectors that are vital, including plantations, mining, and tourism. Thailand, of course, was the first country in the region to develop a standalone NAP, followed by Japan. Malaysia is currently also developing a NAP, and we're pleased that Indonesia has indicated its own desire to do so. National action plans are vital to local and regional efforts to advance business and human rights, as they allow a focus on local context and local priorities, which is key to the success of any business and human rights platform. And they also allow much more clearly for the participation of civil society as stakeholders at the table. The working group understands that there may be several sectors in which the National Strategic Plan will focus, but encourages the plan to also consider more general issues given the diversity of Indonesia's economic landscape. So not just sectors, but you should consider other issues as well. Thus, it may be useful to consider and address broad-based issues such as the issue of gender or women in the workforce, the informal economy, global supply chains, etc. While the scope of the National Action Plan varies from country to country, multi-stakeholder consultation and engagement will help identify priorities. As we encourage states to remain flexible and not predetermine the scope of the NAP. You can't write the NAP before you have your consultations. Some countries have also included issues of corruption prevention as well as environmental considerations in their NAPs. The working group has addressed the connection between business and human rights and corruption in its recent report to the Human Rights Council. Similarly, a new topic on which we encourage states to focus is on the risks to human rights defenders who speak up about business-related human rights abuses and face increasing threats to their security and reprisals. We just launched a specific set of guidance relating to the guiding principles and respect for human rights defenders, and we think this is a very important priority. In general, the working group emphasizes that it is important that there be strong policy coherence via a coordinated national action plan. And the working group, when it hosted its annual UN Forum on Business and Human Rights in November of 2020, focused on the key theme of prevention, preventing business-related human rights abuses, as the key to a sustainable future for people and the planet. Prevention of adverse impacts on people is fundamental for sustainable development. Prevention is also at the core of the guiding principles and their emphasis on proactive, ongoing action by states and business in fulfilling their respective duties and responsibilities. That was the working group's key message at the Global Forum last fall, that the UN guiding principles are a key tool for prevention of negative human rights impacts, and as a result, essential to a strategy for resilient recovery. The COVID-19 pandemic has disrupted supply chains and exposed workers to greater health and economic impacts and risks. The crisis has further increased the vulnerability of populations such as migrant workers, women, and workers in essential sectors such as agriculture and the production of personal protective equipment and medical supplies. The guiding principles can help governments and businesses to ensure that current business and policy decisions do not create further risks to people and the planet. COVID-19 increased risks such as forced labor, for example. So now is not the time to relax labor and human rights standards, but for us all to work collaboratively, locally, nationally, regionally, and globally, to ensure that we do not create or treat economic recovery as a trade-off between GDP and lost lives. Responsible business conduct is not a burden, it is a wise path for sustainability. States need to increase the social safety net while also ensuring respect for the dignity of workers. This means that all states need to think carefully about the impact of new legislation relating to labor and environmental regulation on rights holders. A strategic approach to business and human rights across all sectors can lay the foundations for resilient recovery. Now, the impact of COVID-19's pandemic in Indonesia has created a heavy social impact across Indonesia's manufacturing sector. Multinational responsible business conduct standards across the whole supply chain can be a useful framework to identify solutions to really mitigate or remove the worst impacts of COVID-19. It can allow businesses to develop useful solutions at the local level proactively. They don't need for governments to act. It can also help the financial sector to leverage its capital towards sustainable business, including state-owned enterprises. The guiding principles in closing present an essential roadmap to ensure both that we navigate the current crisis with respect to people, but that we build better forward. The 3 pillars tell us what is needed in practice. States must protect human rights, businesses should respect human rights, and victims need access to effective remedy. I wish you a fruitful dialogue, and I am happy to coordinate and follow up with any of you that have questions. Thank you.
An inspiring and interesting material that was brought by our first keynote speaker. That was a lesson that is very needed at this current time. For the next session, the second keynote speaker will be Mr. Ahmad Taufan Damanik. He is the chairperson of the National Commission on Human Rights of Indonesia. We would like to proudly present to you the curatum vitae from our second keynote speaker. Mr. Ahmad Taufan Damanik is the chairperson of the National Commission on Human Rights of Indonesia. He is a lecturer at the Faculty of Social and Political Sciences of the University of North Sumatra. He had been a freelance consultant of many organizations such as Save the Children Indonesia, World Bank, and the United Nations Children's Emergency Fund, or UNICEF.
He has a very active role in advocating rights of children, especially regarding protection for children in conflict as victims. He finished his bachelor degree from the Faculty of Political and Social Science in the University of North Sumatra, and his master degree had been completed in the University of Essex, United Kingdom. He has been awarded as an exemplary humanitarian, human rights and peace building during Aceh in conflict and situation, and in the 10th anniversary of peace in Aceh from Aceh Peace Forum. We shall now hand this session over to Ms. Taufan Damanik.
Good morning, all participants. Thank you very much for giving me a chance to give keynote speech in Parahyangan Legal Competition 2021. My keynote speech is Pancasila and UN Guiding Principle on Business and Human Rights, Implementation during COVID-19 pandemic and relation with rights of health. Let me start by explaining about Pancasila. Pancasila as a state ideology means that Pancasila is a philosophist groundslaw, the primary resource of value, norms, and rule for laws and regulation in Indonesia, including written law, statutory law, constitution and national law, and unwritten law or oral law, custom, usage, and judicial decision. According to Professor Noto Nagoro, as a state ideology, Pancasila serves as a fundamental principle that is immutable and inviolable, so that there are no single laws and regulations that are not in line with Pancasila. Pancasila is well-shown a way of life, belief, and legal and moral ideals of Indonesia. As a state ideology, Pancasila is a binding national agreement and applied to all citizens without any exception. Its position as a state ideology is stated at the preamble of the 1945 Constitution. Therefore, the national independence of Indonesia shall be composed in a constitution of the state of Indonesia, which is structured in a form of the state of the Republic of Indonesia, with people's sovereignty based on the belief in one and only God, just and civilized humanity, the unity of Indonesia, and a democratic life guided by wisdom in deliberation representation, and by realizing social justice for all the people of Indonesia. The preamble of the 1945 Constitution contains the values of Pancasila that consists of four main ideas. The first is unity. As a unitary state, that main state shall protect the whole Indonesian nation and the entire native land of Indonesia. And unity is important above than individual or groups. This also represents the third pillar, the unity of Indonesia. The second main idea is social justice. The state is obliged to create general welfare, educate the life of the nation, and participate in the world order based on freedom and perpetual peace. This also represents the fifth pillar, social justice for all the people of Indonesia. The third main idea is people sovereignty based on democracy and deliberation representation. This main idea shows that Indonesia is a democratic state. This also represents the fourth pillar of Pancasila, a democracy guided by wisdom in deliberation among representatives. The fourth main idea stated that Indonesia believes in God Almighty and just and civilized humanity. This means that Indonesia upholds humanity and religious practice in their daily life. This also represents the first and the second pillar of Pancasila. Those four main ideas are fundamentals on the establishment of Indonesia that were later articulated into articles and clauses in 1945 Constitution. From the 1945 Constitution, the four main ideas were projected and operationalized into national law, state regulation, and so on. One of our noble nation goals is mentioned in the second main idea that is also written on preamble of the 1945 Constitution, which is to create general welfare for all the people of Indonesia. This general welfare includes jobs availability, increased revenue, and fulfillment of basic rights like education and rights of health. Welfare can also be associated with the increment of Indonesian gross domestic product that can be achieved by providing an economic ecosystem that is sustainable, stable, and well managed. The international world, the welfare state become a benchmark of measurement of how government effort to make their country welfare enough. However, this also poses a challenge due to broaden and deepen gap between developed rich countries and developing countries that are mainly characterized by the abundance of natural resources. Globalization also takes part in increasing concern from the third world on the declining function of the state to make their people's welfare, especially when multinational corporations start to operate within their state. David Corton, in the book When Corporations Rule the World, 1995, said that in the last half of 20th century, there is a major change of human history that marked by the strengthened corporation who's gradually evolved into a dominant institution in which their passion affect the whole country because their power and influence are bigger than the state itself. According to David Corton, multinational corporations have everything in their hands, including capital, technology, human resources, network, and capability to influence the decision-making process inside the government. This combination makes them easier to control natural resources which should be allocated into public interest and people's livelihood. With the power they have, the presence of corporations also triggers conflict with local citizens that bring detrimental effect on them. Realizing that the amount of conflict inflicted by the corporation steadily increases, in 1974, United Nations reached an agreement on the new international economic order. This is an order from the poor state that experienced constant exploitation from multinational corporations and richer states, resulted in low economic growth and broadened and deepened the gap between the poor and the haves. In order to adjust to this situation, those poor states demand accelerated growth in their economy, even distribution between every state and power distribution and reallocation. Besides accepting the new international economic order on June 16, 2011, United Nations Human Rights Council unanimously endorsed United Nations Guiding Principle on Business and Human Rights. 20 member states of the UN Human Rights Council and 12 cross-regional sponsors unanimously agreed to endorse UNGPs. Universal support from many states in the world is important to enforce and implement the UNGPs framework that consists of 3 pillars: protect, respect, and remedy. UNGP sets standards and practices based on international law and social expectation that lay the foundation not only for the future of the international framework, but also on authoritative measure of business process and activity. The UNGP encompasses 3 pillars that are interconnected between each other. One, the first duty to protect human rights, including protection from human rights violation that came from business activity. Second, the corporate responsibility to protect human rights, which means not to violate human rights by avoiding, reduce, and prevent the negative effect from corporate operation. And the last, access to an effective remedy for victims of business-related human rights violation through the judicial and non-judicial mechanism. Previously, corporations cannot be held to pursue their legal responsibility to protect and uphold human rights. This soon no longer happens because UNGPs provide an alternative approach to the current international human rights system that is only based on the main assumption of the state as a duty holder. By involving corporations in the UNGPs framework, it makes them have the same responsibilities as the state. Furthermore, the UNGPs also provide a chance for human rights advocacy to demand responsibility from the corporation as well as state, considering the devastating effect that made by corporations whenever they operate. Let me continue by explaining the strategic role of Komnas HAM. National Commission of Human Rights of the Republic of Indonesia, as commonly known as Komnas HAM, is a state institution that has strategic role to ensure Indonesian government commitment on respecting, protecting, and fulfilling human rights as mandated by the 1945 Constitution of the Republic of Indonesia and Law Number 39, year 1999 on human rights. Within the implementation of their duties and authorities, Komnas HAM has authority to conduct research and study, education and promotion, monitoring and mediation. Komnas HAM has also other roles according to Law Number 26 of year 2000 on Human Rights Code that stated Komnas HAM is allowed to conduct investigation on incident that is suspected as a gross violation of human rights. Until today, there have been more than 12 cases of alleged gross violation of human rights in which their investigation had been completed and the result had been submitted to Attorney General. Thus, the progress can be continued to the next level. As the example, there are mass massacre of 65-66, May riots 1998, disappearance of people during 1998's riot, Talang Sari on 1989 in Lampung, and many others. Komnas HAM has also role as supervisor as mandated on Law Number 40 of year 2008 on the elimination of racial and ethnic discrimination, as well as to be part of task force in social conflict case in national scale occurs in accordance with Law Number 7 of year 2012 on social conflict management. Komnas HAM and business human rights issues. Komnas HAM received approximately 5,000 public complaints every year. Based on annual report of 2019, there are 5,213 complaints. Public complaints relate to negative impact of business operational on each year. In the last 3 years, almost appeared at second rank, as presented on public complaints charts below. You may see corporation business entities. In 2019, there are around 483 complaints. Increase in 2018, complaint is around 1,021. And in 2017, the complaints number is around 866. During 2019, in general, the number of public complaints is decreasing due to COVID-19 pandemic, in which regarding to this situation, Komnas HAM applies limitation on direct complaint. Generally, public complaints relate to corporation or business entities can be classified in two. One, agrarian dispute, includes overlapping claims to land, payment of land compensation. Second, labor dispute, includes the employment termination, inappropriate payment, union busting, and prohibition of strikes, suspension, and dominion. The third is environmental destruction and pollution. Meanwhile, these are corporation classification based on type of business. The one is plantation, the second, manufacture, and the third is mining, mineral, and coal extractive industrial. The fourth is forestry. The fifth, oil and gas. The sixth is fisheries. And the seventh is infrastructure, in line with government programs. For example, New Jakarta International Airport. And the last is Mandalika Circuit project in West Nusa Tenggara. Besides receiving public complaints relating to negative impact of business operational, Komnas HAM also puts efforts by performing mediation as remedy of rights for victims affected by business operational. The second effort that had been done by Komnas HAM in order to ensure number of public complaints is drafting policy paper National Action Plan for Business and Human Rights that had been published in Komnas HAM Regulation Number 1, year 2017, and legalized as a State Gazette Number 267. Recently, the policy making of business and human rights has been taken over by the government. At first, the focal point was coordinating Ministry for Economic Affairs. According to the result of Komnas HAM studies, that ministry's institutions which intersect a lot with business and human rights issues is the ministries or institutions within the coordinating Ministry for Economic Affairs. The focal point at this time is Ministry of Law and Human Rights, in which also take roles as Joint Secretariat of Business and Human Rights for Indonesia. Business and human rights issue has been included in National Action Plan of Human Rights to 2021-2025 and had been legalized on presidential regulation. There are 4 groups belong to business and human rights in National Action Plan: women, children, people with disabilities, and the last, indigenous people. At the outset, Komnas HAM expect that business and human rights can be regulated separately from National Action Plan of Human Rights, considering its subject matters and fairly broad spectrum, hence requires such separate settings. In accordance with that, Komnas HAM is also currently on progress establishing national task force and national strategy for business and human rights. Komnas HAM challenges related to business issues. Speaking about business and human rights, there are at least three stakeholders: government, corporation, and society. Each of them has its own challenges in practicing human rights as the mainstream in business operation. Those stakeholders are interconnected to each other. For instance, the government needs corporation or business to grow the wheel of investment and improve people's welfare. Business entities, corporation needs convenience and sustainability for their business operation, and society as their consumers. This part can be considered as Komnas HAM big challenge and crucial position to equalize every stakeholder. Hence, they will be able to synergize along with human rights instruments as declared in UNGBs. The rise of public complaints related to business operation has correlation with increasing development program carried out both by the central government and regional government. Furthermore, the emergence of various investment, both foreign and local, led to conflict with the community, including indigenous peoples, whose lives are highly dependent on access to natural resources that are close to their lives. The rise of plantation and mining projects has also contributed to the intense agrarian conflict between communities and corporations. The size of the area needed by the corporation for business development versus the need for land for local communities and all indigenous peoples to sustain their life triggers conflict in location, where there is an intersection of region between those two. The basis of land ownership is a major problem that is rarely reconciled, giving rise to conflict between parties. In this conflict, people are often faced with state officials who are supposed to supervise and be law enforcers who adhere to human rights principles. State officials are often seen as more concerned with corporate interests rather than as a support for settlement. The existence of corporation can actually be part of realization of guarantees for the fulfillment of economic, social, and cultural rights for the surrounding community. So far, corporations have managed various efforts. For example, through corporate social responsibility or CSR as companies' obligation, Law number 40 of year 2007 on limited liabilities companies. In order to maintain business continuity, corporations in certain sectors such as oil palm plantation, mining, and manufacturing are also having standardized respect for human rights. There are some reasons for corporations or companies in applying human rights standards in their operation. First is market demands. In an increasingly globalized world, rapid flow of information and the era of liberated information, human rights standards happen to be essential factors in companies' operational. If the corporation or companies commit human rights abuses, accordingly, the market and consumers will respond in a negative way as well. Hence, gradually, it can damage the reputation of the corporation or companies. The second reason, business must have sustainability in which it can be complied by respecting human rights. However, we realize that in order to create such human rights friendly companies, it is important to both set standard of human rights values within the operation and internalize each individual whom operate the companies or corporation. Internalization is required to be practiced by every worker level in companies or corporation, whether the policy maker, management, or operator. Therefore, respect to human rights can become company's culture. In the future, we hope that respect to human rights carried out by business entities will also increase as declared in United Nations Guiding Principle on Business and Human Rights, or UNGPs, to protect, to respect, and remedy. The biggest challenge that exists today is world current condition that is experiencing a COVID-19 pandemic. Without exception, the business sector also suffered a quite heavy problem. Employment termination and budget tightening is in every sector become unavoidable, aggravated by unclear situation about when the pandemic will end. Previously, as the COVID-19 pandemic started to spread in Indonesia since March 2020 earlier, Komnas HAM had press conference encouraging business practitioners to try to diminish employment termination as possible. Besides concerning on employees' rights, Komnas HAM has also developed standard norms and procedure on right on health, putting this right of health as the highest human rights value, especially during this pandemic. The objectives and benefit of the standard norm and procedure are for the government. SNP encourages the government to ensure that there will be no policies and action that are contrary to human rights norms since planning, regulation, and implementation, as well as ensuring legal processes and imposing sanctions on perpetrators for action that violate human rights norms. For law enforcers, SNP enables them to take action to ensure fair legal protection in the protection of human rights and law enforcement. For corporations or the private sectors, SNP encourages them to respect human rights and society, avoid treatment that violates human rights norms, ensure compliance with a fair and appropriate solution for an act that violates human rights. For individuals, communities, and community organizations, SNP makes it possible for them to understand all things related to action that violates human rights norms. Therefore, they can ensure that human rights are protected, do not commit or act that violates human rights norms and can trigger wider social conflict, and build mutual understanding and tolerance. Among all human rights principles, there are three main principles in the right to health: non-discrimination, upholding human dignity, and demanding for state responsibility. Now, give me a time to conclude my presentation. Creating general welfare is a manifestation of the practice of Pancasila. Therefore, it is necessary to develop policies that always put human rights values as the good mainstream. Komnas HAM will continue to encourage every stakeholder to support and implement the UNGPs for preventing and addressing the risk of adverse impact on human rights related to business and corporation operation. In the meantime, during the COVID-19 pandemic, businesses and corporations must give more attention to the rights of health of their workers in order to reduce the spreading of COVID-19 and obey the government rules during the community activities restriction enforcement. Komnas HAM also need to support from every stakeholders to promote and utilize standard norm and procedure on right of health that has been launched at April 2021. With this MSP on rights of health that completes 4 other SNP made by Komnas HAM, I hope this can stimulate and promote not only a conducive human rights situation, but also steady improvement on promotion, upholding, protection of human rights in Indonesia. Thank you very much for your attention. Again, I would like to say thank you also to the committee by inviting me to give my speech. Thank you.
Thank you so much to Mr. Ahmad Taufan Damanik. Before we jump to another session, we would like to inform you that there is an update for our schedule. To all participants, please look at the new schedule that we have shared at the Zoom chat and WhatsApp group. Now, we would like to express how thankful we are to our co-hosts, Office of the United Nations High Commissioner for Human Rights and the National Commission on Human Rights of Indonesia.
The Office of the United Nations High Commissioner for Human Rights is the leading UN entity on human rights. They represent the promotion and protection of the full range of human rights and freedoms all across the world that is set out in the Universal Declaration of Human Rights. The National Commission on Human Rights of Indonesia is an independent body that functions to carry out studies, research, counseling, monitoring, and the mediation of human rights in Indonesia.
These two co-hosts are organizations that are crucial in maintaining peace through the whole world as they uphold human rights that also has a very strong connection to Parahyangan Legal Competition 2021 topic, that is, upholding Pancasila towards human rights-based business and investment environment in Indonesia.
Also, we want to say thank you to our media partners, Ardan Radio, Hukum Online, and Berita Satu, that has already helped provide information regarding the Parahyangan Legal Competition 2021 to all participants that have attended here.
In addition, we would like to express our deepest gratitude to Anand Kilana Haryanto and Hermanto Lovern, Anggraini and Partners, and Nutrifood Indonesia Limited Liability Company for being our sponsors in Parahyangan Legal Commission 2021.
There is also an exciting promotion from our sponsor, Nutrifood Limited Liability Company. They would like to give away vouchers that give 30,000 rupiah off to the first 300 of our participants that shop for a minimum of 200,000 rupiah in nutrimart.co.id by using the code NHUBJabar. And for further information, please contact Diri in WhatsApp number 085798483828.
Other than that, to all participants that have attended the Zoom meeting are able to find practical legal reference in premium stories that present reviews of important issue, doctrines to jurisprudence, and court decision in one comprehensive article by subscribing for a price of 42,000 rupiah per month at hukumonline.com/stories. Ladies and gentlemen, now we will enter the rest session. All participants in this session are expected to be back here at 13:25 to continue the webinar session.
The recess session will be longer than the norm because today is a Friday, a day where Muslims have their weekly Friday prayers in the afternoon. The extra recess time allocated is for all the Muslim men participants to be able to have enough time to do the Friday prayer before coming back to the Zoom meeting.
Good afternoon and see you again.
I use my personal story of coming to Australia as a refugee, and I share the story of arriving into a community that is very diverse and welcomed me with open arms. And I share that story because I want to show people what kind of community we could be if we welcomed everyone who arrived in our community and in and amongst us. We could be more diverse, we could be stronger together.
One thing we do need to avoid is stories of violence, stories of hate, because stories of positivity teach us all to work together to be able to reflect better on the things that are common to us and that we all believe in.
We think it's really important to combat hate speech with more speech. So it's really important for us to promote a pluralistic media environment.
Mobilizing consumers to speak to the companies that they shop with and encourage those companies to advertise more responsibly and avoid advertising with media that fuel hatred.
I think all around us we see migrant communities often, and I think it's important that we have those conversations with those communities. And I think that at the end of the day, I think develops and grows a much more inclusive society for all of us.
This message that we have more in common than what divides us is remarkably powerful. You can sometimes hear it and think, well, come on, that's kind of obvious. But actually, it's not what people are hearing every day. What they're hearing every day is change, difference, the threat of the other. And they need reminding that, in fact, as people, most of us, most of the time, have the same hopes, the same aspirations, and that we do have much more in common than what divides us.
Apa itu hak asasi manusia? Hak asasi manusia adalah hak yang melekat pada manusia sebagai anugerah Tuhan yang wajib dihormati, dijunjung tinggi, dan dilindungi oleh negara, hukum, dan semua orang. Secara umum, HAM bersifat kodrati, yang artinya HAM adalah hak yang telah menjadi kodrat manusia. Selain itu, HAM bersifat universal, yang artinya HAM secara umum berlaku di seluruh dunia dengan tetap menghormati adat istiadat dan budaya negara masing-masing. HAM juga bersifat langgeng, yang artinya HAM adalah hak manusia sejak dari dikandungan hingga meninggal. Manusia memiliki hak yang tidak dapat dikurangi dalam keadaan apapun, yaitu hak untuk hidup, hak untuk tidak disiksa, hak kemerdekaan pikiran dan hati nurani, hak beragama, hak untuk tidak diperbudak, hak untuk diakui sebagai pribadi di hadapan hukum, dan hak untuk tidak dituntut atas dasar hukum yang berlaku surut. Hak-hak itu adalah hak yang tidak dapat dikurangi dalam keadaan apapun. Namun tidak semua HAM dapat dikurangi, ada juga hak-hak yang dibatasi. Hak seseorang dapat dibatasi oleh undang-undang, misalnya, setiap orang berhak untuk memiliki dan membangun tempat tinggal. Namun orang lain tidak berhak mengganggu atau menggusur tempat tinggal orang lain sewenang-wenang, walaupun itu untuk membangun tempat tinggalnya sendiri, atau pemerintah tidak berhak sewenang-wenang menggusur tempat tinggal orang lain tanpa menjalani prosedur. Untuk menjamin hak asasi manusia, negara dan pemerintah wajib untuk melindungi, memajukan, menegakkan, dan memenuhi hak asasi manusia. Negara dan setiap orang wajib untuk menghormati HAM. Artinya, tidak boleh melakukan tindakan atau mengganggu HAM orang lain. Misalnya, masyarakat yang sudah menikmati haknya untuk beribadah secara bebas tidak boleh diganggu. Negara berkewajiban untuk melindungi HAM. Artinya, ketika ada pihak lain yang mengganggu HAM, negara wajib memberikan perlindungan. Contohnya, ada orang yang sedang menyampaikan haknya untuk berekspresi, lantas ada pihak lain yang mengganggu. Maka negara, misalnya polisi, harus melindungi orang yang sedang menyampaikan ekspresinya itu. Negara berkewajiban untuk memenuhi HAM. Artinya, negara harus mengambil langkah-langkah supaya setiap orang menikmati HAM secara lebih baik dan meningkat dari waktu ke waktu. Contohnya, hak anak atas pendidikan. Maka, negara wajib menyediakan gedung sekolah yang layak, guru yang berkualitas, dan materi pelajaran yang bermutu baik. Selain itu, setiap orang wajib menghormati hak asasi orang lain dan tertib di dalam kegiatan bermasyarakat. Namun dalam menjalankan hak dan kebebasannya, setiap orang wajib tunduk kepada pembatasan yang telah ditetapkan undang-undang agar dapat menghormati hak dan kebebasan orang lain. Apabila seseorang atau sekelompok orang atau aparatur negara dengan sengaja atau tidak sengaja mengurangi, menghalangi, membatasi, atau mencabut HAM orang lain, maka hal tersebut adalah pelanggaran terhadap hak asasi manusia. Pelanggaran hak asasi manusia akan menjadi akar dari segala permasalahan dari suatu negara. Mari kita ciptakan dunia tanpa kekerasan dan diskriminasi, saling menghormati dan menghargai sesama manusia. HAM untuk semua. Laporkan setiap bentuk pelanggaran HAM, jangan diam.
I use my personal story of coming to Australia as a refugee, and I share the story of arriving into a community that is very diverse and welcomed me with open arms. And I share that story because I want to show people what kind of community we could be if we welcomed everyone who arrived in our community and in and amongst us. We could be more diverse, we could be stronger together.
One thing we do need to avoid is stories of violence, stories of hate, because stories of positivity teach us all to work together to be able to reflect better on the things that are common to us and that we all believe in.
We think it's really important to combat hate speech with more speech. So it's really important for us to promote a pluralistic media environment.
Mobilizing consumers to speak to the companies that they shop with and encourage those companies to advertise more responsibly and avoid advertising with media that fuel hatred.
I think all around us we see migrant communities often, and I think it's important that we have those conversations with those communities, and I think that at the end of the day, I think develops and grows a much more inclusive society for all of us.
This message that we have more in common than what divides us is remarkably powerful. You can sometimes hear it and think, well, come on, that's kind of obvious. But actually, it's not what people are hearing every day. What they're hearing every day is change, difference, the threat of the other. And they need reminding that, in fact, as people, most of us, most of the time, have the same hopes, the same aspirations, and that we do have much more in common than what divides us.
Apa itu hak asasi manusia? Hak asasi manusia adalah hak yang melekat pada manusia sebagai anugerah Tuhan yang wajib dihormati, dijunjung tinggi, dan dilindungi oleh negara, hukum, dan semua orang. Secara umum, HAM bersifat kodrati, yang artinya HAM adalah hak yang telah menjadi kodrat manusia. Selain itu, HAM bersifat universal, yang artinya HAM secara umum berlaku di seluruh dunia dengan tetap menghormati adat istiadat dan budaya negara masing-masing. HAM juga bersifat langgeng, yang artinya HAM adalah hak manusia sejak dari dikandungan hingga meninggal. Manusia memiliki hak yang tidak dapat dikurangi dalam keadaan apapun, yaitu hak untuk hidup, hak untuk tidak disiksa, hak kemerdekaan pikiran dan hati nurani, hak beragama, hak untuk tidak diperbudak, hak untuk diakui sebagai pribadi di hadapan hukum, dan hak untuk tidak dituntut atas dasar hukum yang berlaku surut. Hak-hak itu adalah hak yang tidak dapat dikurangi dalam keadaan apapun. Namun tidak semua HAM dapat dikurangi, ada juga hak-hak yang dibatasi. Hak seseorang dapat dibatasi oleh undang-undang, misalnya, setiap orang berhak untuk memiliki dan membangun tempat tinggal. Namun orang lain tidak berhak mengganggu atau menggusur tempat tinggal orang lain sewenang-wenang, walaupun itu untuk membangun tempat tinggalnya sendiri. Atau pemerintah tidak berhak sewenang-wenang menggusur tempat tinggal orang lain tanpa menjalani prosedur. Untuk menjamin hak asasi manusia, negara dan pemerintah wajib untuk melindungi, memajukan, menegakkan, dan memenuhi hak asasi manusia. Negara dan setiap orang wajib untuk menghormati HAM. Artinya, tidak boleh melakukan tindakan atau mengganggu HAM orang lain. Misalnya, masyarakat yang sudah menikmati haknya untuk beribadah secara bebas tidak boleh diganggu. Negara berkewajiban untuk melindungi HAM. Artinya, ketika ada pihak lain yang mengganggu HAM, negara wajib memberikan perlindungan. Contohnya, ada orang yang sedang menyampaikan haknya untuk berekspresi, lantas ada pihak lain yang mengganggu. Maka negara, misalnya polisi, harus melindungi orang yang sedang menyampaikan ekspresinya itu. Negara berkewajiban untuk memenuhi HAM. Artinya, negara harus mengambil langkah-langkah supaya setiap orang menikmati HAM secara lebih baik dan meningkat dari waktu ke waktu. Contohnya, hak anak atas pendidikan. Maka, negara wajib menyediakan gedung sekolah yang layak, guru yang berkualitas, dan materi pelajaran yang bermutu baik. Selain itu, setiap orang wajib menghormati hak asasi orang lain dan tertib di dalam kegiatan bermasyarakat. Namun dalam menjalankan hak dan kebebasannya, setiap orang wajib tunduk kepada pembatasan yang telah ditetapkan undang-undang agar dapat menghormati hak dan kebebasan orang lain. Apabila seseorang atau sekelompok orang atau aparatur negara dengan sengaja atau tidak sengaja mengurangi, menghalangi, membatasi, atau mencabut HAM orang lain, maka hal tersebut adalah pelanggaran terhadap hak asasi manusia. Pelanggaran hak asasi manusia akan menjadi akar dari segala permasalahan dari suatu negara. Mari kita ciptakan dunia tanpa kekerasan dan diskriminasi, saling menghormati dan menghargai sesama manusia. HAM untuk semua. Laporkan setiap bentuk pelanggaran HAM, jangan diam.
I use my personal story of coming to Australia as a refugee, and I share the story of arriving into a community that is very diverse and welcomed me with open arms. And I share that story because I want to show people what kind of community we could be if we welcomed everyone who arrived in our community and in and amongst us. We could be more diverse, we could be stronger together.
One thing we do need to avoid is stories of violence, stories of hate, because stories of positivity teach us all to work together to be able to reflect better on the things that are common to us and that we all believe in.
We think it's really important to combat hate speech with more speech. So it's really important for us to promote a pluralistic media environment.
Mobilizing consumers to speak to the companies that they shop with and encourage those companies to advertise more responsibly and avoid advertising with media that fuel hatred.
I think all around us we see migrant communities often, and I think it's important that we have those conversations with those communities. And I think that at the end of the day, I think develops and grows a much more inclusive society for all of us.
This message that we have more in common than what divides us is remarkably powerful. You can sometimes hear it and think, well, come on, that's kind of obvious. But actually, it's not what people are hearing every day. What they're hearing every day is change, difference, the threat of the other. And they need reminding that, in fact, as people, most of us, most of the time, have the same hopes, the same aspirations, and that we do have much more in common than what divides us.
Apa itu hak asasi manusia? Hak asasi manusia adalah hak yang melekat pada manusia sebagai anugerah Tuhan yang wajib dihormati, dijunjung tinggi, dan dilindungi oleh negara, hukum, dan semua orang. Secara umum, HAM bersifat kodrati, yang artinya HAM adalah hak yang telah menjadi kodrat manusia. Selain itu, HAM bersifat universal, yang artinya HAM secara umum berlaku di seluruh dunia dengan tetap menghormati adat istiadat dan budaya negara masing-masing. HAM juga bersifat langgeng, yang artinya Apa itu hak asasi manusia? Hak asasi manusia adalah hak yang melekat pada manusia sebagai anugerah Tuhan yang wajib dihormati, dijunjung tinggi, dan dilindungi oleh negara, hukum, dan semua orang. Secara umum, HAM bersifat kodrati, yang artinya HAM adalah hak yang telah menjadi kodrat manusia. Selain itu, HAM bersifat universal, yang artinya HAM secara umum berlaku di seluruh dunia dengan tetap menghormati adat istiadat dan budaya negara masing-masing. HAM juga bersifat langgeng, yang artinya HAM adalah hak manusia sejak dari dikandungan hingga meninggal. Manusia memiliki hak yang tidak dapat dikurangi dalam keadaan apapun, yaitu hak untuk hidup, hak untuk tidak disiksa, hak kemerdekaan pikiran dan hati nurani, hak beragama, hak untuk tidak diperbudak, hak untuk diakui sebagai pribadi di hadapan hukum, dan hak untuk tidak dituntut atas dasar hukum yang berlaku surut. Hak-hak itu adalah hak yang tidak dapat dikurangi dalam keadaan apapun. Namun tidak semua HAM dapat dikurangi, ada juga hak-hak yang dibatasi. Hak seseorang dapat dibatasi oleh undang-undang, misalnya, setiap orang berhak untuk memiliki dan membangun tempat tinggal. Namun orang lain tidak berhak mengganggu atau menggusur tempat tinggal orang lain sewenang-wenang, walaupun itu untuk membangun tempat tinggalnya sendiri. Atau pemerintah tidak berhak sewenang-wenang menggusur tempat tinggal orang lain tanpa menjalani prosedur. Untuk menjamin hak asasi manusia, negara dan pemerintah wajib untuk melindungi, memajukan, menegakkan, dan memenuhi hak asasi manusia. Negara dan setiap orang wajib untuk menghormati HAM. Artinya, tidak boleh melakukan tindakan atau mengganggu HAM orang lain. Misalnya, masyarakat yang sudah menikmati haknya untuk beribadah secara bebas tidak boleh diganggu. Negara berkewajiban untuk melindungi HAM. Artinya, ketika ada pihak lain yang mengganggu HAM, negara wajib memberikan perlindungan. Contohnya, ada orang yang sedang menyampaikan haknya untuk berekspresi, lantas ada pihak lain yang mengganggu. Maka negara, misalnya polisi, harus melindungi orang yang sedang menyampaikan ekspresinya itu. Negara berkewajiban untuk memenuhi HAM. Artinya, negara harus mengambil langkah-langkah supaya setiap orang menikmati HAM secara lebih baik dan meningkat dari waktu ke waktu. Contohnya, hak anak atas pendidikan. Maka, negara wajib menyediakan gedung sekolah yang layak, guru yang berkualitas, dan materi pelajaran yang bermutu baik. Selain itu, setiap orang wajib menghormati hak asasi orang lain dan tertib di dalam kegiatan bermasyarakat. Namun dalam menjalankan hak dan kebebasannya, setiap orang wajib tunduk kepada pembatasan yang telah ditetapkan undang-undang agar dapat menghormati hak dan kebebasan orang lain. Apabila seseorang atau sekelompok orang atau aparatur negara dengan sengaja atau tidak sengaja mengurangi, menghalangi, membatasi, atau mencabut HAM orang lain, maka hal tersebut adalah pelanggaran terhadap hak asasi manusia. Pelanggaran hak asasi manusia akan menjadi akar dari segala permasalahan dari suatu negara. Mari kita ciptakan dunia tanpa kekerasan dan diskriminasi, saling menghormati dan menghargai sesama manusia. HAM untuk semua. Laporkan setiap bentuk pelanggaran HAM, jangan diam.
personal story of coming to Australia as a refugee, and I share the story of arriving into a community that is very diverse and welcomed me with open arms. And I share that story because I want to show people what kind of community we could be if we welcomed everyone who arrived in our community and in and amongst us. We could be more diverse, we could be stronger together.
One thing we do need to avoid is stories of violence, stories of hate, because stories of positivity teach us all to work together to be able to reflect better on the things that are common to us and that we all believe in.
We think it's really important to combat hate speech with more speech. So it's really important for us to promote a pluralistic media environment.
Mobilizing consumers to speak to the companies that they shop with and encourage those companies to advertise more responsibly and avoid advertising with media that fuel hatred.
I think all around us we see migrant communities often, and I think it's important that we have those conversations with those communities, and I think that at the end of the day, I think develops and grows a much more inclusive society for all of us.
This message that we have more in common than what divides us is remarkably powerful. You can sometimes hear it and think, well, come on, that's kind of obvious. But actually, it's not what people are hearing every day. What they're hearing every day is change, difference, the threat of the other. And they need reminding that, in fact, as people, most of us, most of the time, have the same hopes, the same aspirations, and that we do have much more in common than what divides us.
Apa itu hak asasi manusia? Hak asasi manusia adalah hak yang melekat pada manusia sebagai anugerah Tuhan yang wajib dihormati, dijunjung tinggi, dan dilindungi oleh negara, hukum, dan semua orang. Secara umum, HAM bersifat kodrati, yang artinya HAM adalah hak yang telah menjadi kodrat manusia. Selain itu, HAM bersifat universal, yang artinya HAM secara umum berlaku di seluruh dunia dengan tetap menghormati adat istiadat dan budaya negara masing-masing. HAM juga bersifat langgeng, yang artinya HAM adalah hak manusia sejak dari dikandungan hingga meninggal. Manusia memiliki hak yang tidak dapat dikurangi dalam keadaan apapun, yaitu hak untuk hidup, hak untuk tidak disiksa, hak kemerdekaan pikiran dan hati nurani, hak beragama, hak untuk tidak diperbudak, hak untuk diakui sebagai pribadi di hadapan hukum, dan hak untuk tidak dituntut atas dasar hukum yang berlaku surut. Hak-hak itu adalah hak yang tidak dapat dikurangi dalam keadaan apapun. Namun tidak semua HAM dapat dikurangi, ada juga hak-hak yang dibatasi. Hak seseorang dapat dibatasi oleh undang-undang, misalnya, setiap orang berhak untuk memiliki dan membangun tempat tinggal. Namun orang lain tidak berhak mengganggu atau menggusur tempat tinggal orang lain sewenang-wenang, walaupun itu untuk membangun tempat tinggalnya sendiri. Atau pemerintah tidak berhak sewenang-wenang menggusur tempat tinggal orang lain tanpa menjalani prosedur. Untuk menjamin hak asasi manusia, negara dan pemerintah wajib untuk melindungi, memajukan, menegakkan, dan memenuhi hak asasi manusia. Negara dan setiap orang wajib untuk menghormati HAM. Artinya, tidak boleh melakukan tindakan atau mengganggu HAM orang lain. Misalnya, masyarakat yang sudah menikmati haknya untuk beribadah secara bebas tidak boleh diganggu. Negara berkewajiban untuk melindungi HAM. Artinya, ketika ada pihak lain yang mengganggu HAM, negara wajib memberikan perlindungan. Contohnya, ada orang yang sedang menyampaikan haknya untuk berekspresi, lantas ada pihak lain yang mengganggu, maka negara, misalnya polisi, harus melindungi orang yang sedang menyampaikan ekspresinya itu. Negara berkewajiban untuk memenuhi HAM. Artinya, negara harus mengambil langkah-langkah supaya setiap orang menikmati HAM secara lebih baik dan meningkat dari waktu ke waktu. Contohnya, hak anak atas pendidikan. Maka, negara wajib menyediakan gedung sekolah yang layak, guru yang berkualitas, dan materi pelajaran yang bermutu baik. Selain itu, setiap orang wajib menghormati hak asasi orang lain dan tertib di dalam kegiatan bermasyarakat. Namun dalam menjalankan hak dan kebebasannya, setiap orang wajib tunduk kepada pembatasan yang telah ditetapkan undang-undang agar dapat menghormati hak dan kebebasan orang lain. Apabila seseorang atau sekelompok orang atau aparatur negara dengan sengaja atau tidak sengaja mengurangi, menghalangi, membatasi, atau mencabut HAM orang lain, maka hal tersebut adalah pelanggaran terhadap hak asasi manusia. Pelanggaran hak asasi manusia akan menjadi akar dari segala permasalahan dari suatu negara. Mari kita ciptakan dunia tanpa kekerasan dan diskriminasi, saling menghormati dan menghargai sesama manusia. HAM untuk semua. Laporkan setiap bentuk pelanggaran HAM, jangan diam.
Here's my personal story of coming to Australia as a refugee, and I share the story of arriving into a community that is very diverse and welcomed me with open arms. And I share that story because I want to show people what kind of community we could be if we welcomed everyone who arrived in our community and in and amongst us. We could be more diverse, we could be stronger together.
One thing we do need to avoid is stories of violence, stories of hate, because stories of positivity teach us all to work together to be able to reflect better on the things that are common to us and that we all believe in.
We think it's really important to combat hate speech with more speech. So it's really important for us to promote a pluralistic media environment.
Mobilizing consumers to speak to the companies that they shop with and encourage those companies to advertise more responsibly and avoid advertising with media that fuel hatred.
I think all around us we see migrant communities often, and I think it's important that we have those conversations with those communities. And I think that at the end of the day, I think develops and grows a much more inclusive society for all of us.
This message that we have more in common than what divides us is remarkably powerful. You can sometimes hear it and think, well, come on, that's kind of obvious. But actually, it's not what people are hearing every day. What they're hearing every day is change, difference, the threat of the other. And they need reminding that, in fact, as people, most of us, most of the time, have the same hopes, the same aspirations, and that we do have much more in common than what divides us.
Apa itu hak asasi manusia? Hak asasi manusia adalah hak yang melekat pada manusia sebagai anugerah Tuhan yang wajib dihormati, dijunjung tinggi, dan dilindungi oleh negara, hukum, dan semua orang. Secara umum, HAM bersifat kodrati, yang artinya HAM adalah hak yang telah menjadi kodrat manusia. Selain itu, HAM bersifat universal, yang artinya HAM secara umum berlaku di seluruh dunia dengan tetap menghormati adat istiadat dan budaya negara masing-masing. HAM juga bersifat langgeng, yang artinya HAM adalah hak manusia sejak dari dikandungan hingga meninggal. Manusia memiliki hak yang tidak dapat dikurangi dalam keadaan apapun, yaitu hak untuk hidup, hak untuk tidak disiksa, hak kemerdekaan pikiran dan hati nurani, hak beragama, hak untuk tidak diperbudak, hak untuk diakui sebagai pribadi di hadapan hukum, dan hak untuk tidak dituntut atas dasar hukum yang berlaku surut. Hak-hak itu adalah hak yang tidak dapat dikurangi dalam keadaan apapun. Namun tidak semua HAM dapat dikurangi, ada juga hak-hak yang dibatasi. Hak seseorang dapat dibatasi oleh undang-undang, misalnya, setiap orang berhak untuk memiliki dan membangun tempat tinggal. Namun orang lain tidak berhak mengganggu atau menggusur tempat tinggal orang lain sewenang-wenang, walaupun itu untuk membangun tempat tinggalnya sendiri. Atau pemerintah tidak berhak sewenang-wenang menggusur tempat tinggal orang lain tanpa menjalani prosedur. Untuk menjamin hak asasi manusia, negara dan pemerintah wajib untuk melindungi, memajukan, menegakkan, dan memenuhi hak asasi manusia. Negara dan setiap orang wajib untuk menghormati HAM. Artinya, tidak boleh melakukan tindakan atau mengganggu HAM orang lain. Misalnya, masyarakat yang sudah menikmati haknya untuk beribadah secara bebas tidak boleh diganggu. Negara berkewajiban untuk melindungi HAM. Artinya, ketika ada pihak lain yang mengganggu HAM, negara wajib memberikan perlindungan. Contohnya, ada orang yang sedang menyampaikan haknya untuk berekspresi, lantas ada pihak lain yang mengganggu, maka negara, misalnya polisi, harus melindungi orang yang sedang menyampaikan ekspresinya itu. Negara berkewajiban untuk memenuhi HAM. Artinya, negara harus mengambil langkah-langkah supaya setiap orang menikmati HAM secara lebih baik dan meningkat dari waktu ke waktu. Contohnya, hak anak atas pendidikan. Maka, negara wajib menyediakan gedung sekolah yang layak, guru yang berkualitas, dan materi pelajaran yang bermutu baik. Selain itu, setiap orang wajib menghormati hak asasi orang lain dan tertib di dalam kegiatan bermasyarakat. Namun dalam menjalankan hak dan kebebasannya, setiap orang wajib tunduk kepada pembatasan yang telah ditetapkan undang-undang agar dapat menghormati hak dan kebebasan orang lain. Apabila seseorang atau sekelompok orang atau aparatur negara dengan sengaja atau tidak sengaja mengurangi, menghalangi, membatasi, atau mencabut HAM orang lain, maka hal tersebut adalah pelanggaran terhadap hak asasi manusia. Pelanggaran hak asasi manusia akan menjadi akar dari segala permasalahan dari suatu negara. Mari kita ciptakan dunia tanpa kekerasan dan diskriminasi, saling menghormati dan menghargai sesama manusia. HAM untuk semua. Laporkan setiap bentuk pelanggaran HAM, jangan diam.
Good afternoon, and welcome back to Parahyangan Legal Competition 2021 webinar session. We want to welcome back to all participants for this webinar. Continuing to the next webinar session will be conducted in the same rule. Ladies and gentlemen, for the next webinar will be brought by Ms. Sagita Adesywi as the moderator for the second webinar. Ms. Sagita Adesywi is from the United Nations Development Programme's Country Office for Indonesia. We will proudly present you the curriculum vitae for our first moderator.
Ms. Sagita is the United Nations Development Programme Indonesia Business and Human Rights Specialist. She has experience working on a wide range of development initiatives, including reducing the impact of HIV and AIDS in the workplace and wider communities, children's rights and business, water and sanitation, and government transparency and accountability.
Prior to joining the United Nations Development Programme, she worked with the United Nations Programme on HIV and AIDS, United Nations Children Emergency Fund, Child Fund International, the World Bank, and the United States Agency for International Development. She holds Master in Globalization and Development and is passionate about promoting respect for human rights through responsible business initiatives. And now, for this webinar session, we will hand it over to Ms. Sagita Adesywi.
Thank you so much, Tiara and Daryl. I hope you can hear my voice clear.
Yes, I can hear your voice clearly, Ms. Sagita.
Okay, thank you. Hello everyone, selamat siang and welcome to the session of application of the UNGP or United Nations Guiding Principle focusing on human rights due diligence or HRDD practice. Thank you to Parahyangan Catholic University, the National Commission of Human Rights of the Republic of Indonesia or KOMNAS HAM, and the United Nations Human Rights Office of High Commissioner for having me here. As introduced by Daryl and also Tiara, I'm Sagita Adesywi, Business and Human Rights Specialist of UNDP Indonesia. And I have the great pleasure to be your moderator in the session today. In the first session, Anita Ramasastry shared that UNGP is a key tool to help state and business to not create further risks on human rights within the framework of protect, respect, and remedy. Further, Bapak Ahmad Taufan has also shared that complaints received by KOMNAS HAM on the negative impact of business operation is ranked as the second highest of violation against human rights in Indonesia. As shared by both Anita and Bapak Ahmad Taufan, since a decade ago of the launch of the UNGPs, there are so many gaps and challenges that need to be addressed by both the state and also businesses. Importantly, amid the pandemic now, and even more so beyond the pandemic. I am very much looking forward to the reflections of our panelists further on these topics. And without further ado, I would like to introduce you to them. Joining with us today, we have Commissioner Roberto Cadiz, the Focal Commissioner for Business and Human Rights, Environment, International Humanitarian Law, Peace and Sustainable Development Goals at the Commission on Human Rights or CHR of the Republic of the Philippines. Since 2007, Commissioner Cadiz has managed projects funded by the USAID International Foundation for Electoral System and the United Nations Development Program or UNDP. These projects also involve government agencies such as the Supreme Court of the Philippines, Department of Education, and the CHR. Commissioner Cadiz has counseled in judicial reform and public interest cases. He was also one of the private prosecutors in the impeachment case against former Supreme Court Chief Justice Renato Corona. His affiliations related to his advocacies include Parity Politica or Money and Politics, Transparency and Accountability Network, and Supreme Court Appointments Watch. Currently, Commissioner Cadiz oversees the Commission Center for Crisis, Conflict, and Humanitarian Rights, as well as the Human Rights Education and Promotion. He is also presently handling the petition on climate change filed before the CHR. Commissioner Cadiz has a bachelor's degree in philosophy and law from the University of the Philippines. And with us today, too, we have Bapak Eko Riyadi, a lecturer at the Faculty of Law, the Islamic University of Indonesia, and the director of Center for Human Rights Studies at the same institution. He finished his master degree at Faculty of Law of the Islamic University of Indonesia with a focus on human rights law and constitutional law. He is also teaching on the same subject. His commitment to the human rights discourse is shown in various scientific works that have been published in some books and journal articles. In 2021, he published 2 scientific articles entitled Portrait of Fulfilling to the Right to Accessibility of Higher Education for Persons with Disabilities in Yogyakarta, and Strategic Litigation Against Public Participation or SLAP, a legal-based threat to freedom of expression. As a lecturer cum activist, Bapak Eko Riyadi also helped the National Human Rights Commission to develop a complaint mechanism, standard norms, and regulations on the right to health. He also involved in various human rights advocacy programs with the institution he leads, USAM UII. In addition, he also actively involved as a journal reviewer and a member of the Southeast Asian Human Rights and Peace Studies Network and the Indonesian Human Rights Association. I'm so delighted to have such terrific speakers with us today. So before we start the session, I would like to share that all participants can post questions in the Q&A function. Now I'm going to turn to our panelists. And first, we are going to hear from Commissioner Cadiz, who will share his reflection on whether climate change as a business and human rights issues is subject to human rights due diligence or HRDD. Commissioner Cadiz, the floor is yours. Thank you. I think we already have Commissioner Cadiz here with us, Tiara and Daryl, right?
Yes, but I think because there is a technical difficulties, I think he is unable to join.
Okay, are we then? Let's wait for 1 or 2 minutes until he is able to join us. Please be patient. During the Zoom webinar, it's very common for us to have some difficulties in the technical side. So let's just wait for a moment. Maybe I'll check from the committee. I hope from the committee there is someone who is helping the commissioner.
I think the commissioner is already joined the Zoom, but I think he's unable to hear us.
Good afternoon to everyone. I'm sorry for the slight delay. Some technical issues I encountered. Should I start already?
Yes, please, Commissioner Cadiz. The floor is yours. Thank you.
All right, thank you very much. Well, let me start by thanking the organizers for the kind invitation to Parahyangan Catholic University, to KOMNAS HAM, and of course to the OHCHR. It's my privilege and a pleasure to be speaking before you this afternoon. So I shall be talking about the nexus or the intersectionality between and among human rights, business, and climate change. So let me start by saying that climate change is a human rights issue because it negatively impacts practically the whole gamut of human rights. As widely recognized under the Universal Declaration on Human Rights and different conventions such as the International Convention on Civil and Political Rights, International Convention on Economic, Social, Cultural Rights, and other conventions and protocols concerning human rights, including also common international law. So the obvious human rights impacted are the rights to life, the right to health, the right to water, sanitation, education, etc. These are just some of the examples of civil, political, economic, social, cultural rights that are impacted by climate change. So in that sense, very concrete sense, we can say that climate change is a human rights issue. Climate change is also an existential threat that is now being posed, and it is because of primarily the trigger is man-made activity, specifically the production of greenhouse gas emissions resulting from the burning of fossil fuel. And when we say that climate change is the tipping point of existential climate change right now is man-made activity, that is what is meant when we say that there is that anthropogenic dimension to climate change, although we do recognize that there are also natural causes to climate change. The tipping point, I would like to underscore, that is causing this existential threat to humankind is anthropogenic activity. And within that anthropogenic dimension of climate change is the big role that businesses play. That is why climate change, we say, is also a business issue. So given the premises that I mentioned, we say that climate change is both a human rights and a business issue. So under the under the UN, United Nations Guiding Principles on Business and Human Rights, we read or we learn or we are told of the duty of states and the responsibility of businesses to human rights. We already know, of course, even without the UN Guiding Principles on BHR, the states are duty-bound to uphold and protect human rights. We have known that for a long time under, again, the UN Declaration on Human Rights, the International Convention on Civil and Political Rights, the International Convention on Economic Social Rights, the different treaties and conventions around human rights, and then under also customary international law. Everybody knows already the duty of states to protect and uphold human rights. But the contribution of the UN Guiding Principles on Business and Human Rights is that it says that businesses, although they are not parties to treaties and conventions under international law, also have a responsibility to respect human rights. This is the contribution of the UN Guiding Principles. Thus, these being principles, the appeal of the UNGP BHR to businesses in a sense is an appeal to morality of businesses and not a threat of a legal sanction, because these are just soft laws, UN Guiding Principles being soft laws and not hard laws. Now, part of the duty of states to human rights is to enact domestic laws within their jurisdictions that will compel or that will hold to legal accountability businesses within their own respective jurisdictions, because, as we said earlier, businesses are not subject to treaties under international law. It is now the obligation of the different countries, the different states, to enact laws that would compel businesses operating within their jurisdictions to comply with their responsibilities to human rights. And these laws should be based on standards set under international law. And it is now common understanding, common agreement among lawyers and human rights advocates that states must require businesses to comply, as I said, with international standards when they enact laws. What are examples of international standards that different states must require businesses within their jurisdictions to comply with? A common example is the enactment of laws regarding fair wages, for example, humane working conditions, upholding union rights. These are examples of certain standards that different states must enact and must force or require the businesses within their jurisdictions to observe. Another standard is the conduct of, and this is where we are now going into, require businesses to conduct human rights due diligence. What does this mean? Human rights due diligence. This means that businesses should, before operating, study the impact of their business operations on human rights in order to preempt or avoid abuses to human rights. And a concrete example of concrete element of human rights due diligence is the conduct of, for example, environmental impact assessment, human rights impact assessment, of course, and now merging climate change impact assessment. So again, we underscore that businesses must be required. I'm sorry.
Please continue.
Sorry, that businesses must be required to conduct impact assessments again in the fields of human rights, the environment, and now climate change. We all know that our climate system is a part of our environment, and that climate change also impacts human rights. I keep on emphasizing that as a basis for the human rights due diligence obligation that is supposed to be imposed by states on businesses. But even where states, because we observe in our climate change inquiry that some states do not require the conduct of human rights due diligence on businesses before they begin operating. So we are saying that even where states have no requirement over, have no laws requiring businesses within their jurisdictions to conduct human rights due diligence, we say that big businesses, especially multinational corporations, have a moral obligation, no longer legal, because if the states have no laws that imposes on them the legal obligation, still businesses would have a moral obligation to conduct such assessments guided by the UN Guiding Principles on Business and Human Rights. Now, in the context of climate change, what is the main duty of states and the main responsibility of businesses to mitigate climate change? So the global challenge right now is to transition the global economy from dependence on fossil fuel to reliance on clean and renewable energy. Okay? In the context of climate change, this is now the global challenge that faces all of us, to transition our global economy from dependence on fossil fuel to reliance on clean, renewable energy. And what do we mean by alternative clean renewable energy? We mean solar energy, wind energy, geothermal energy, hydro energy, and now even hydrogen energy. The technology is now there, and we just need to scale up and hasten this transition. And we say that all acts of obstruction, all acts of obfuscation, all acts that tend to delay and derail the global transition from fossil fuel dependence to reliance on renewable energy, all acts that would tend to obstruct and delay this are, at the very least, immoral and, at most, illegal. With regard to the carbon majors, when we say carbon majors, these are the major producers of fossil fuel. They should not block, they should not derail, they should not delay this global effort towards renewable energy. They should not obfuscate climate science. They should not confuse the people that climate change is a hoax. They should not influence their governments from withdrawing from climate accords, such as the Paris Agreement. The Paris Agreement is a global effort to address and mitigate climate change, and the carbon majors, being a powerful industry, should not influence their governments, say, by funding campaign efforts of politicians, so that when they get elected, they will vote or influence their governments to withdraw from the Paris Agreement, as is what we saw during the Trump administration when it decided to withdraw from the climate accord. We also say that the carbon majors must now invest more on renewable energy rather than on further developing and searching for more oil fields. At present, we already know that there is already a glut in our oil fields. There is already more oil fields that we need, and further investments by carbon majors on this will subject them also to possible suits from their shareholders and investors, because these investments will end up as stranded assets later on. When we say stranded assets, assets that will no longer be useful, because right now the global trend, if they do not keep on blocking them, is already towards renewable energy. There is already strong evidence that on a per kilowatt hour basis, it is now cheaper to produce electricity out of renewables than out of fossil fuels. But the tendency of the carbon majors as business enterprises is to prolong global dependence on fossil fuel, because that is the easy way out. That is their business as usual for continuing with their profitable business operations. With regard to states, they must individually and in cooperation with each other under the doctrine of erga omnes in international law to create a policy environment that will catalyze the global transition to renewable energy. This is now the primary obligation of states. They must refrain from further giving incentives and loans and tax breaks and tax holidays to business enterprises that are geared towards further production of fossil fuel, rather than giving these incentives to business enterprises concerning fossil fuel activities. They should now channel these resources to incentivize the renewable energy sector. And they should scale up the renewable energy sector infrastructure, because as I said, there is already the technology to harness all this energy as against fossil fuel. So I would like to end up with a simple message to all of us here as global citizens, because as global citizens, we also do play a role in hastening the transition towards renewable energy. We global citizens have three roles that are powerful to influence, to avert the existential threat right now posed by climate change. And what are these three roles of the global citizens? First, we have a role as consumers. As consumers, we can influence the behavior of businesses. We can stop patronizing fossil fuel instead of investing on, instead of, for example, due to lifestyle changes, consuming too much fossil fuel, we can cut down on our consumption. We also have a role, the second role, as investors. We do invest as global citizens on companies, and we should be mindful on investing on green companies right now rather than on carbon polluting companies. And finally, we have a role and power as electors, as citizens who choose our leaders, as voters, as global citizens. We should now be including in our decision-making processes in electing our leaders the stand of our politicians regarding the environment and climate change. An example that I would want to point out, for example, is the recent elections in the United States, where this was a big campaign issue during the presidential elections. President-elect Joe Biden made this a big campaign issue, climate change. And luckily, he was elected by a majority of the US electorate. And this has resulted in the rejoining of the US back into the climate accord or the so-called Paris Agreement. So here we can see the important role that global citizens play in shaping our environment and averting dangerous climate change. The responsibility is not only on governments, not only on businesses, but also on global citizens. So I would like to end my talk here, and I would be open to, if there is an open forum later on, to answer your questions. Thank you very much.
Thank you so much, Commissioner Cadiz. That was a really comprehensive and interesting insight that you have shared. I just want to highlight a few things that you have said here. That
this meeting is being recorded.
Even though one state may not be part of any treaty, but the businesses in that country is responsible to follow the local law, which is it encourages the business to be accountable on their responsibility on how they operate in the country. And also would like to highlight one interesting point that you have made, that in terms of the climate change, that as a global citizen, we have a say. We have a say to shape our environment by being mindful of, for example, be part of the decision making, how we elect our leaders to see where they stand on the environment. I think that is really powerful message that you share, especially for our participants here from the university, where they play their role in voicing their concerns against the environment and human rights. Because, as you mentioned earlier, that environment issue is very much relevant to the human rights, because we have the right to health, to water, to clean air, and this is very much a strong linkages between the climate change, the environment, and also human rights. So thank you so much for that, Commissioner Cadiz. We will get back to you later on the Q&A function. For now, I'm going to move on to our next panelist, Bapak Eko Riyadi, who will share his insights on the potential applications of human rights due diligence on the right to health in Indonesia. Bapak Eko Riyadi, I'll give you the floor. Thank you.
Can you take me out also?
Thank you, Mbak Sagita.
Ya, Pak.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. I was so happy to be invited speaking here at the wonderful seminar today. So I am Eko Riyadi. I am a lecturer at the Islamic University of Indonesia. I am sitting here speaking to all of you because of my contributions to national human rights institutions when they draft norm and standard setting of the right to health. I will show you, especially for Indonesian students, because I think all of you have to know this standard. This is the norm and standard setting number 4 on the right to health that has been officially adopted by national human rights institutions at 2001. So it is adopted by KOMNAS HAM. In this norm and standard setting, we can read all the things that is related to right to health from the perspective of human rights. So this SNPs, in Indonesia we can call it SNPs, Standard Norma dan Pengaturan, consists of 353 paragraphs. So it is so big regulations. In terms of, in terms of human rights, SNP is like general comment under the international human rights law. So SNP is the interpretations of certain right that is guaranteed under the international human right in terms of national or domestic mechanism. So any one of you, if you would like to, for example, writing an article or something, you have to look at the SNP to enrich your article. So today I would like to speak only related to the right to health. Thanks to Commissioner Cadiz that talking very in a big picture on climate change, business, and the state obligations. And now I just would like to talk about very specific issues that is related to business and human right due diligence in terms of right to health. Can you see my PowerPoint, Mbak Sagita? Okay, yep. My presentations will be consist of 5 chapters. Number 1 is about the pillar of UNGP. Number 2 is corporate responsibility. Number 3 is corporate due diligence in terms of right to health. And then next is state obligations. And the last one is about intellectual property right. All of this content will be related to right to health. All my presentations is based on the norm and standard setting 4 on the right to health. Yeah. But because of this SNP is very big regulations, yeah, let's say. So I just would like to differ about 12 from 456 paragraphs. So it is actually very limited point on the SNP. I will start by talking about the 3 pillars of UNGP. So this morning, and also Commissioner Cadiz just now, talk about the pillar of UNGP that are set obligations to protect, corporate responsibility to respect, and access to remedy. In terms of the right to health, state has the obligations to make sure that there is a protections mechanism made by the state to avoid the abuses conducted by companies. In terms of health, state have the obligations to make sure that there is no abuses, human rights abuses by companies in terms of health through appropriate policies, regulations, and decisions. If there is for example, pharmaceutical companies, for example, or vaccine companies, or let's say the companies that has the main activities in export and import vaccines or medicines, so the state has the obligations to make sure that there is no human rights abuses done by the companies. The second is corporate responsibility to respect. Until now, the concept of obligations for companies is still responsibility to respect. It means that there is no obligations as the obligation of the state about human rights, because in human rights perspective, state has 3 obligations. Number 1 is obligations to protect, to fulfill, and to respect. And then the corporations under the UNGP principle has the responsibility to respect, meaning that companies are responsible for respecting the right to health by not committing human rights abuses. So it is important for companies to make sure that their operations, their business activities is not violating, it's not abusing, it's not committing human rights abuses for a person, for an individual. So the corporations, for example, in terms of the corporations that has the core business of, let's say, producing medicines or vaccines, they have to make sure that all their product is safe, and also all their activities must be appropriate, must be based on human rights standard, and they have to avoid committing human rights abuses. And the third is access to remedy. So the state has the obligations to make a mechanism for victims of violations or abuses, especially the right to health, to access the redress schemes both through judicial or non-judicial mechanism. Now we have serious situations about the pandemic of COVID-19. We have so many bad news recent now. There are so many friends, our relatives that got a serious problem with COVID-19. So in these situations, the state has the obligations to develop the mechanisms that all Indonesian citizens having a problem with COVID-19 will be having a mechanism to access the remedy, to access the medicines, and so on and so on. And the second is about corporate responsibility. The there are so many responsibility based on human right, but in this SNP, we are only proposing three main obligations or responsibility for the corporations. Number one is companies are requested to express their commitment to human rights. So in terms of in terms of UNGP, the companies has the obligations to make a rule, to make SOP on how their business activities are in line with human rights standard. They have to express the commitment by making and developing a standard operating procedure and mechanism to make sure that all the activities will be conducted respecting human rights. Number two, companies are requested to carry out a rigorous process to identify, prevent, reduce, and quantify the impact of human rights problems that arise from their activities. It is the standard for the companies. They have to identify, prevent, and reduce any potential act that is potential violate human rights. Number three is companies are requested to develop an access to remedy for negative impact of their activities. So not only state-based mechanism, but companies are also required to develop their own mechanism to deliver the remedy for the person who are becoming victims of their business activities. So this kind of standard for the corporations related to human rights. The next is about the corporate due diligence. Number one, we try to advocate that the business entities or companies that are engaged in the business sector are required to respect the right to health in accordance with the environmental impact analysis. As Commissioner Cadiz taught just now, there are so many problems related to environmental issues. We just read the situations of massive flood in Germany, in Belgium, in China. I think it is because of the situations of climate change. So all business sector are requested to make sure that their business activities is in accordance with the situations of environmental impact. And the next is about it is also related to business companies, that parent company must be responsible for violations or abuses of the right to health by its subsidiaries. It is important because in business law, we have the doctrine of spread legal entity. But in terms of human rights, we would like to emphasize that hand company has the obligations to make sure that their subsidiaries companies will be always respecting and responsible for the avoiding human rights violations by their business activities. And this is the corporate due diligence number two. Companies that produce goods that have negative implications for health are required to include health warnings in clear and easily legible writing. And also it is important accompanied by a picture that is easily understood by the people. For example, in Indonesia, there are so many people that still smoking, because smoking is having a negative impact for health. So they have to put the health warning with a certain picture, talking that or delivering a message that smoking is not good for health. And the next is food and beverage companies are requested to list the nutritional content and ingredient used in the packaging in easy to understand by the consumers. It is also important in Indonesia because there are so many snacks found in every market. Yeah, it is important to make sure that the companies must be writing or putting the nutritional content or ingredients, so we as a consumers can try to understand and also make a considerations. We will buy a certain product or not. The next is state obligations. In terms of health, state is obliged to provide medicines and or vaccines. So today I would like to emphasize once more that vaccines is human right, because today we have a serious problem related to vaccines. I think last week we just struggling to send a message to government, to dispense, to delete the regulations on commodifications of vaccines, and we succeed because vaccine is a human right. The obligations of the state to provide a vaccine for all persons, for all Indonesian citizens. Commodifications of vaccines is serious human right violations. And the next is every person or company engaged in a health sector must be in a situation of a fair and reasonable competition. So it is not cause concentrations of economic power in certain business actors, which may result in increase or scarcity of goods or services in the health sector. It is also important, So we have to deliver, we have to send a strong message to our government that medicines, vaccines must be free for Indonesians in terms of pandemic situations today. Because as we know, there are so many group of people, there are so many businessmen that would like to get a lot of money in terms of these situations. We have to always send a message, strong message to Indonesia's government, to businessmen, that in these situations, right to health is human right. This is the obligations of the state to respect and to protect our right to health. The last one is about the vaccines. It is important also. We just know that Sarah from English, she released her intellectual property right in terms of AstraZeneca vaccines that she found. We also drafted in our SNP that patent right by pharmaceutical companies can be dispensed with to protect the public right to access to medicines. Also, in terms of pharmaceutical or biotechnology product, government has the right or authority to release the patent to avoid the expensive of vaccines or medicines. So it can be used for Indonesian citizens to release for this from these situations. Individual intellectual property right should not replace the right to life and health. It is also important. And the next one, this is the last point that of my presentations. In terms of intellectual property right, we know that there is a TRIPS, by WTO, that the applications of flexibility clauses is possible. We have to send a message for Indonesian government here in Indonesia to use applications of flexibility clauses in terms of TRIPS to make sure that every person here in Indonesia can have an access to vaccines and medicines. That is all my presentations today. Thank you for your attentions. Happy to respond your questions or respond. Thank you. I will give the time back to Mbak Sagita. Thank you, Mbak Sagita.
Thank you so much, Bapak Eko Riyadi. This is a very interesting and comprehensive insight that you have shared with us. And I have not done as well some interesting things that you have said, that you mentioned that a parent company must be held responsible for violations of the right to health by its subsidiaries. So it's really resonates well with the UNGPs, where it says wherever business operates, whether in the host country or in the origin country and throughout its supply chain, and whenever there are some violation against human rights, they must be accounted responsible for their actions. And then what I also found interesting from your reflection is that during this pandemic, of course, our right to health is really emphasized, and the relationship to the business is how that we know the state is responsible, have the obligation to protect our human rights, the right to health by providing the vaccines. And we could see some initiative in Indonesia, for example, many companies as well collaborate with the government to subsidize the vaccine provision by what we call vaksin gotong royong. So it's subsidized by the companies. So this is where the companies respond to the pandemic to also support the government programs. I think there's also one of the initiative that it's some of the good practices that it's been done by the company. And I noted as well that you mentioned about how companies is required, for example, for food and beverages company, they need to clearly state the ingredients or the nutrition facts in their product. And I think this is very, very much relevant to our situation right now. For example, now I think many people is really looking at how to keep our immune system well. So many people now looking at vitamins and supplements. And I'm taking myself as example. For example, I don't know much about supplement or vitamins. So for example, I have one here in my near me. So I don't know if this could be seen in the screen. So this is all the ingredients facts. And if I read it, there is only a few things that I would understand. There are so many things, maybe like, what is this, And I think maybe from the business side, they could have some, to have a common understanding for common people like us, like me, for example, to understand what is good and what is not. Because, for example, I just learned while I'm searching for these supplements or vitamins that actually natural flavor is not natural. It is a man-made or artificial made in the, it's not natural. So this is something that could be misleading. And this is I think also against human rights, right? And so again, this is a really interesting fact that you have shared. And you have shared about the intellectual property rights or patent rights. The Professor Sarah Gilbert from the University of Oxford, who developed the AstraZeneca vaccine. Yes, we learned that she has waived the IP or patents right for the vaccine, which is, I think this is one of the example of put human first before profit. This is really great. Although in the one of their discussion with WHO and others, she and other vaccine developer also said that waiving intellectual property rights will not be enough to resolve the COVID-19 vaccine issues. But I think, in my opinion, because there are so many other things to ensure, but I think this would certainly release one barrier for wider public to assess it. So I think this is also a great initiative. So thank you so much again for this reflection, Bapak Eko. I have another note.
The recording has stopped.
But I will keep that for now and get back to it later when we have time. As now I see there are many questions already in the Q&A for both Pak Eko and also for Commissioner Cadiz. I will read one question from, let me read it, the question here, from Ananda Firdiansa. And he wanted to ask that about the draft of the new and renewable energy or rancangan undang-undang energi baru dan terbarukan. This draft about they have a pro and cons, because there are some part of this draft that needs to be considered again, like for example the use of the nuclear energy, because many experts and environmentalists don't agree about this section about the use of the nuclear energy. It used a lot of resources in terms of the financial resources, and it made some risks to human rights as well. So I would like to ask perhaps first to Pak Eko Riyadi, and then later on to Commissioner Cadiz, about your insight or your reflection about one of element in our new regulation on a new about the renewable energy on the use of nuclear energy. Perhaps I will give the floor to Pak Eko first. Thank you, Pak.
Thank you, Mbak Sagita. So responding to Oswaldo Aranha questions, but the nuclear energy, this is very old debate, in terms of using nuclear. What happened now between Iran and Western countries is also related to the idea to use nuclear energy. But if we look at the previous incident or accident by Russia, for example, there are thousands of people who were dead because of nuclear energy. In China also, it is also related to using nuclear energy. And if we look at the Second World War, it is also related to the nuclear energy. I stand for saying no to nuclear energy because we have a proof that there are so many previous accidents that there are so many people, thousands of people were dead because of, let's say, unsafe technology of nuclear. So yes, I know that nuclear is actually has the, let's say, advantage for a people, but we have to make sure that the technology of using nuclear must be safe, must be how to say, must be there is no hold of the technology, because if there is still a problem with the technology, the potential threat to human is very big. So in terms of Indonesia, I think, until now I would say that I stand to say no for nuclear. Because not if we talk about nuclear, in terms of fuel, we have still so many problems, right? The accidents about the let's say, for example, Lumpur Lapindo until now is still hasn't been solved by Indonesian government. So how if we develop nuclear energy? So I think it is so dangerous.
Thank you so much, Pak Eko, for your comment. That's really great. So, because you see that we are not ready in terms of the technology, so it poses a greater risk to human rights. All right. May I know, please, perhaps ask Commissioner Cadiz to also share his insights on this nuclear energy. Thank you.
All right. Thank you very much for that question. Well, in our report, we have not recommended nuclear energy as an alternative source of energy because, as was earlier observed, we do not deem it as a viable and safe alternative source in the long term, observing the accidents that have happened in industrial countries such as Japan, no? And Russia and all this. So we are advocating solar energy, wind energy, geothermal energy, water energy, and even hydrogen energy. But we also recognize the fact that in some countries, for example, such as France, their primary source of energy is nuclear energy. But for my country, for the Philippines, we did not recommend that. Aside from the fact, by the way, that it is very expensive. On a per kilowatt hour basis, nuclear energy is probably the most expensive, especially if you consider right now that solar energy is already cheaper than to produce, to produce kilowatt hour. Solar energy and wind energy are already cheaper than fossil fuel energy. So for a country that has no nuclear power plant, why should we recommend the establishment of nuclear power plants when the other alternatives are already cheaper? But we do respect the decision of other countries. Thank you.
Thank you so much, Commissioner Cadiz, for your insights. So yeah, when there is not other alternative that is not as expensive as the other option as a nuclear energy, then maybe perhaps a more inclusive or participatory decision making that involves so many various stakeholders would provide a great opportunity on this discourse. Okay, I think we have, I would like to move to another question that we have one question also from YouTube. So we have many questions here on the Zoom platform, but we also have some audiences from the YouTube, which is really great. And we have one question from the YouTube asking about, from Anna Keller, asking about to Commissioner Roberto Cadiz about, would you kindly give any good examples for government incentive to support the transition to renewable energy in Asia? So some good example from the government.
Okay, we have recommended that in our in our resolution or report. There are already I don't know about other governments. But in our government, there are incentives given to inventors, for example. And I remember more than 2 or 3 decades ago, there was a Filipino inventor who actually produced an engine that relied on hydrogen by the use of electrolysis, meaning the separation of oxygen from 2 molecules of hydrogen in water, and taking the hydrogen from water and using it as a source of energy for running cars. So these are an example of incentives. In my country, we are not as rich as the other countries, but I know, for example, such as in Germany, which is the leading country in Europe that now relies on alternative energy, although its use of alternative energy has still not overtaken its reliance on fossil fuel. I know that Germany has provided a lot of funding and incentives to even individual households for the purchase and installation of solar energy. There are many examples, but the important point to underscore right now is that the technology is already there. The technology is there to harness solar energy, to harness wind energy, and all we need is to provide the infrastructure to scale up these alternative sources. And government has a lead role in providing that incentive, not only in terms of subsidizing the ordinary households from utilizing these forms of energy, but also in incentivizing research, funding research, universities, individual researchers to improve, for example, electrical storage, battery technology, etc. The challenges that are needed to be addressed to scale up alternative, clean, safe sources of renewable energy.
Thank you so much, Commissioner Cadiz. So again, the government and also the global citizen have an important role to influence the decision making to push forward the investment that is more green and responsible, not just to environment but also to human rights. Thank you, Commissioner Cadiz. And I think we still have time. Let me check first for our time. Yeah, I think, okay, we still have time for more questions because we have many more questions here. I would like to pick one about the EU mandatory human rights due diligence. This is from Dian. She is or he is asking about this EU mandatory environmental and human rights due diligence that has been planning to be enacted, and she would like, or he would like to know about, specifically to Bapak Eko Riyadi, what do you think about the proposed mandatory human rights due diligence, and how do you think that Indonesia may possibly have some regulation that is close to this initiative? Pak Eko, the floor is yours. Thank you.
Yes, EU, I think, is the regional organizations of the countries where human rights mechanism is very strong. So comparing to ASEAN, for example, is so far away. AU, they have European Commissions, they have European Court of Human Rights. ASEAN, we still have OHCHR, ASEAN Intergovernmental Commission, is still intergovernmental commissions that has very limited authorities of human rights. So also related to environment, I think, but maybe Commissioner Cadiz can make a good response of this, because of, I mean, so many countries in ASEAN, they don't feel that we have a serious problem related to environment, because our location is so far away from North Pole, for example. So it is hard for us to send a message for ASEAN communities, that we have a serious problem related to climate change, related to environmental issues. How about the initiative to protect environment in Indonesia? Actually, we have a special regulations on environment, but I think because of the last act of Cipta Kerja, Omnibus Law, on creating work, we have new challenges in terms of protecting environment, because in the last regulations that we made, there is some kind of liberalizations of environmental issues. So if you ask, is it possible for Indonesia to propose this initiative? I should say yes, but I think the challenges is bigger than the potential advocacy to adopt those kind of regulations. Thank you, Mbak Sagita.
Thank you, Pak Riyadi. Commissioner Cadiz, perhaps you have some take for this question. Thank you.
Okay, thank you very much. So we have observed, and this is not surprising, that environmental consciousness is higher among industrial nations compared to developing nations. So it is not surprising that European countries and that the European Convention on Human Rights, for example, would speak more strongly about protecting the environment. This is a function of also of the level of education and consciousness of the population. So in Asian countries, even in the Philippines, climate change is not considered as a serious issue compared to other issues, such as, for example, in my country, extrajudicial killings, poverty, etc. But in industrial countries where they have solved most of the housing, education, poverty issues, they are now looking at more the future. They are now more environmentally conscious. So this is really a challenge, because whether you are from we live in one biosphere, we live in one globe, and we should all be conscious about climate change. So I guess the challenge to ASEAN governments and even other governments from, let's say, developing countries such as, let's say, the countries in the African continent, is to include in their educational system a strong curriculum regarding environmental protection and climate change. This is the only way, because if people are not aware, if people do not see that this is a serious problem, then they will not behave as proactively as the ones that we see in Europe. And by the way, let me mention as a good example what is happening in the Netherlands, where a lot of legislation and court rulings are being issued, forcing businesses and even their very own government to be more conscious about climate change in relation to their obligations under the European Convention on Human Rights, and as also underscored and elaborated upon and emphasized under the Paris Agreement.
Thank you, Commissioner Cadiz and Pak Eko, for your comments on this. I think because we are already almost about the end of our session, I would like to pose one final question. I would like to ask Pak Eko and also Commissioner Cadiz just very brief comment, maybe just 2 or 3 sentences about one question from Daphne about what would you suggest to the young generation, the academics, the activists, about what kind of action, activity, or contribution for the young generation that they could do to promote more environmentally friendly business considering the climate change? Just a brief suggestion for our young generation. Thank you, Pak Eko and Commissioner Cadiz.
Do you want me to answer first?
Yes.
All right. So we have already seen an example of this student action to address climate change in the last convention of parties leading up to that, where students from all over the globe, millions of them, actually boycotted their classes, went out into the streets to demand the older generation to be more conscious and proactive regarding the climate change issue. So this is one thing. The younger generation can influence the older generation and demand this older generation to be more mindful of the future. The other thing that they can do, because as I earlier stated, they will be electing their leaders. So they choose leaders who are more mindful of climate change and the environment.
Thank you, Commissioner. Pak Eko, please.
Okay, thank you, Sagita. I have two things for all of you, young generations. Number one is please reduce or decrease the consumption of unimportant things. It is important. Number two, you have to be always sending a message to our government. Commissioner Cadiz said to old generations to make sure that their business activities, to government to always put the environmental issues as one of the most important things, because we are living for the next generations. It is important. Thank you, Mbak Sagita.
Okay, thank you so much, Bapak Eko Riyadi and Commissioner Cadiz. So the highlights for our young generation is be mindful, be part of the discussion, voice out the concern to help our practices within business and human rights to be better. So thank you so much again for your reflection today, for answering all the questions. And with this, I would like to end this session and thank to Bapak Eko again and Commissioner Cadiz for a very interesting discussion today. We have so many questions in the Zoom platform as well as from the YouTube. It means that the discussion is very intriguing for many young generations. And I would like to also thank the participants for tuning in, and our apologies, we cannot share or answer all of the questions. And please stay tuned for the next session. And thank you everyone. Have a good continuation of the webinar. Stay healthy. Thank you.
Thank you very much.
Thank you.
Thank you so much to Ms. Sagita Adesywi for being our first moderator in the second webinar session.
To the moderator and speakers for the first webinar, please don't leave the Zoom meeting yet, as there will be a photo-taking session at the end of this webinar. Also, for the speakers and moderator, the Dean would like to greet you all after the webinar closes in a designated breakout room. Continuing to the third webinar session, it will be conducted in the same room. Ladies and gentlemen, for the next webinar, it will be brought by Ms. Katia Chirizzi as the moderator for the third webinar session. Ms. Katia Chirizzi is from the Office of the United Nations High Commissioner for Human Rights. We would like to proudly present to you the curriculum vitae from our second moderator. Ms. Katia Chirizzi joined the UN Office of the United Nations High Commissioner for Human Rights in 2007. Working in Nepal until 2012, heading a field office first and the ESCR anti-discrimination section later.
She then worked in several countries of the Asia-Pacific region, including India, Bangladesh, Bhutan, Maldives, and Sri Lanka, both from the headquarters and in the field. In 2015, she joined the Office of the United Nations High Commissioner for Human Rights, Regional Office for Southeast Asia in Bangkok, where she is the deputy representative, also leading the office works on business and human rights.
From 1999 to 2007, Ms. Katia Chirizzi worked for the Organization for the Security and Cooperation in Europe in Kosovo and Serbia, including as the head of the Anti-Discrimination Section and Deputy Director of the Department of Human Rights and Rule of Law in Kosovo. And now, for this webinar session, we will hand it over to Ms. Katia Chirizzi.
To Ms. Katia Chirizzi, we will hand this webinar session to Ms. Katia Chirizzi. Am I audible?
Ladies and gentlemen, please wait for a moment. There have been some technical difficulties.
While waiting for Ms. Katia Chirizzi, we would like to thank our co-hosts, Office of the United Nations High Commissioner for Human Rights and the National Commission on Human Rights of Indonesia. Also, we want to say thank you to our media partner, Ada Radio, Hukum Online, and Berita Satu, that already helped provide information regarding the Parahyangan Legal Competition 2021 to all participants that attended here. In addition, we would like to express our deepest gratitude to Anand Kilana Haryanto and Hermanto Lovern, Anggranian Partners and Nutrifood Indonesia Limited Liability for being our sponsor in Parahyangan Legal Competition 2021. Ms. Katia, am I audible right now? While waiting for Ms. Katia, we will again like to inform you about the promotion for our sponsor, Nutrifood Limited Liability Company. They would like to give away voucher that give 30,000 rupiah off for the first 300 of our participants that shop for minimum 200,000 in nutrimat.co.id. Ms. Katia, am I audible?
Yes, I can hear you now. Can you hear me?
Yes, Ms. Katia, you're audible.
Okay, and I'm extremely sorry for the inconvenience. I think this is our reality when we are all connected online, but my Zoom just froze and I had to log out and log in again.
It's okay, Ms. Katia.
Okay, well, thank you very much, and a very good afternoon to everyone and the friends connected. It's a true privilege for our own office and for myself to moderate this extremely important session, which is so well connected to the discussion which took place so far. In particular, what we just said in the preceding session was a very good segue into what we are about to discuss, which is safeguarding civil space and the role of business community in the protection of human rights defenders. Now, civil society participation is one of the most important aspects to achieve a healthy democratic society. And as provided by international human rights standards, states have the primary duty to ensure respect and protection of human rights defenders including those working on business and human rights related issues. As noted in the speakers of the previous sessions, the UN Guiding Principles on Business and Human Rights clearly establish that businesses have a responsibility to respect human rights and to address any adverse impact on the rights arising from their acts or omissions of their own or the business to which they are connected. The key elements of a safe and enabling environment for human rights defenders and an effective investment and operating environment for businesses, they are closely interlinked. Human rights and environmental defenders, and we heard a lot in the previous session about environmental human rights defenders, journalists, lawyers, and the anti-corruption campaigners are key agents of change, and they contribute greatly to safeguard human rights and the rule of law. And as such, both companies and human rights defenders have a shared interest in an environment which respects the rights to freedom of expression, association, and assembly, and is characterized by non-discrimination, transparent, and accountable government, freedom from corruption, and the respect from the rule of law. So this session will really provide an overview on increasing restrictions faced by civil society and human rights defenders, and explore some of the drivers and benefits of business action in their support and protection, and discuss emerging good practices related to business and human rights defenders. Now, it is my great pleasure to introduce the two speakers we will have for this session, who really don't need any introduction, as they're very well known to friends and colleagues in Indonesia and beyond in the region. The first speaker who will join us today is Professor Alimalto Kibiak, who is the chairperson of the Commission of the National Human Rights Commission on Violence Against Women, KOMNAS HAM. And we see here a summary of her background and her great achievements. She will be presenting us on the first subtopic foreseen under this session, which is safeguarding civic space and the role of business community and protecting human rights defenders, including women and environmental human rights defenders. So it is really my great pleasure now to hand over the floor to you, and we really look forward to your thoughts and reflections. Over to you.
Thank you very much, Ibu Kathy, and also it's honored for me to be here, part of the speakers in the great event. And congratulations for Parahyangan Catholic University who have this wonderful program. Okay, let me share my PowerPoint that I already provide. Just a second. Okay. I just want to make a match. Okay, there are specific topics that I need to present today, and we will discuss together about how the role of business community and protection for human rights defenders, including women and also environmental human rights defenders. There are 4 things that I'm going to talk about. First, about general principle in glance, because I already heard many times this in this conference, and also the problem about human rights issue in business and women vulnerability, and also the women empowerment principle and recommendation. But first of all, let me introduce about Komnas Perempuan. Yeah, Komnas Perempuan, or National Commission on Violence Against Women, established in response to strong public demand at that time in 1998, especially from women, for the state to take responsibility for violence against women. There are a lot of problems that have at that time relating to the sexual attacks, including mass rape against Chinese women during May 1998. rights, and also Komnas Perempuan is one of national mechanism to protect women's human rights, established by Presidential Decree 1998. There are 2 mandates and also 5 tasks. First, to build a conducive environment for the elimination of all forms of violence against women. And the second one, to increase prevention effort against all forms of violence against women, protection and fulfillment of women's rights in Indonesia. For tasks, there are 5 tasks. First, promote public awareness. And second, conducting research and review relevant laws and regulations. And the third, monitor and report on violence against women on women's human rights, and provide input and recommendation to executive, legislative, and judicial branches of the government. And the last one, develop regional and international cooperation. This is about Komnas Perempuan. Okay, now I'm going to talk about this one. I just want to remind us about the basic principle, guiding principle on business and human rights. These guiding principles are grounded in recognition of states' existing obligation to respect, protect, and fulfill human rights and fundamental freedoms. And the second one, the rule of business enterprises as specialized organs of society performing specialized function required to comply with all applicable laws and to respect human rights. And the third, the need for rights and obligation to be matched to appropriate and effective remedies when it happens. So basically, these 3 principles, there are, each principle has basic principle and operational principle. For the state, which is the pillar of the state, due to protect, there are 1 to 10 principle, and for the company's pillar is responsibility to respect and also the victim. The pillar of victim is access to remedy. So there are 31 principle from when we're talking about human rights and also business. Now, I will not explain these 31 principles, but I will focus on the issue of women's rights. When we talk about women's rights issues in business and women vulnerability, there are some discussion. First, women experience discrimination in terms of access to business and opportunities for leadership position. So relating to the leader position in the company and also in business and opportunity. Discrimination occurs because of patriarchal laws and policies. For example, difficulty getting credit from the bank, stereotypes that women cannot lead, etc. Also, women are also victims of business practices at various points in the value chains and have an impact on female workers and the surrounding female community. Women are very vulnerable to bad practices, especially many women work in the informal sector, as we know, and also domestic workers, and many of them lack of legal protection. Discrimination against women in law and practice. Human rights violations experienced by women in the context of business activities are a combination of existing gender-based discrimination with an imbalance of power between business actors and women individually. Gender discrimination is considered a cultural practice, so companies are not responsible for it. So there are some idea among the companies that this is cultural practice, so it's not our responsibility, for example, like this. So human rights issues, transnational companies and other business groups began to be discussed in 2005 at the United Nations, and also as we learn a lot today, talking about the 3 pillars, which is protect, respect, and remedy. Women's empowerment principle. Equality means business. These principles were developed by UN Women and the UN Global Compact and are recognized as the first global code of conduct related to gender justice in business. General Assembly resolution requests the United Nations Global Impact Local Network to promote the women empowerment principles and to create awareness of the many ways in which business can promote gender equality in the workplace, marketplace, and also community. So 7 women's empowerment principle. First, giving women equal opportunity to sit as company leader, provide fair treatment to women and men in the workplace, ensuring occupational health and safety, promote education, training, and career development for women, and implementing business development, supply chain, and market practices that practice women empowerment. Promote equality through community initiative and advocacy. And the last one, publishing achievement in gender equality. This is 7 women's empowerment principle. Now, when we're talking about women's rights, it's not far from CEDAW. As we know that CEDAW as the instrument of women's rights relating to business or business world. It consists of some principle which is relating to, for example, substantive equality, non-discrimination, and state obligation. And also substantive quality is talking about laws, policies, program, services must produce equal opportunity, equal access to this opportunity, and equal result benefit. Article 2E, CEDAW, GR number 28, is talking about the state obligation to protect women from discrimination by private sector, including in business area. And Article 14, women in rural area, we can use these articles when talking about cases of companies clearing land in rural area. So this CEDAW we can use as instrument when talking about women's rights relating to business. Okay, CEDAW women's rights at work. Although the UN Guiding Principle do not provide for legal obligation in business, but CEDAW required state parties to ensure that not state actors do not violate the right guaranteed in human rights instrument. The CEDAW committee can integrate the UN Guiding Principle in state report through concluding observation and raise the state obligation to protect women against violation committed by business or business world. Businesses must not only consider the implication of human rights in their business activity, but they must also take additional steps to review the impact on women and what is required by CEDAW to ensure women's rights are respected. CEDAW also requires state party to ensure that a law prohibiting businesses from terminating women on the ground of pregnancy, maternity leave, and also marital status. These include ensuring that they continue to receive appropriate wages or social benefit during maternity leave without the risk of losing their previous position and providing special protection for pregnant women. And there are 3 things that we have already talked about, the 3 pillars, protect, respect, and remedy, and identify the role of the state, companies, and civil society. Company must apply due diligence mapping of potential human rights violation by involving human rights experts, groups that are likely to become victims, and other stakeholders, follow up the finding by taking mitigation action. And also submitting the finding and potential human rights violation, ensure that there is remedy and compensation, company and country, and CSOs must see these 3 pillars as interconnected and ensure that both country and companies carry out their duties and ensure that remedies are met. This is how we use to look at the issue. Okay, government policy on social conflict. This is what from the Komnas Perempuan research. the Indonesian government has issued the action plan for the protection and empowerment for women and children in social conflict, as we call RAN P3AKS 2020-2024. In response to this, Komnas Perempuan has been asked to form an internal working team to support the implementation of RAN P3AKS. Komnas Perempuan also provide input, particularly in involving women substantively and doing women and children empowerment. Komnas Perempuan appreciate the Ministry of Women Empowerment and Child Protection's effort to provide self-protection facilities for women human rights defenders in service provider institution during the pandemic. However, substantively, the Indonesian government still has not guaranteed protection for women rights defenders. Women human rights defenders have vulnerability in defending and upholding human rights when they are deemed to be opposed to the government or entrepreneurs. Intimidation, threat, and also the criminalization they experience, targeting physically, psychologically, and also their sexuality. Komnas Perempuan report shows that the risk of women human rights defenders work not only for themselves, but also for their families and relatives. They also experience long-lasting social stigma. Impact of agrarian conflict, because we also talking about human rights development there in environment, agrarian conflict and women's vulnerability. In the last 5 years, maybe not Mbak Sandra can also talk about this. In the last 5 years, complaint to Komnas HAM saw that the conflict area reached 2,000 hectares and spread across 36 provinces in various sectors. It is recorded that 42.3% or 48.8 million people live in the forest area. Conflict occurred, among others, in the plantation, forestry, mining, infrastructure, state property sector, customary land, and also the environment, which are often accompanied by violence. Meanwhile, Komnas Perempuan note that during monitoring in the mining area, for example, in East Kalimantan, the construction of hydropower plant in South Sulawesi and oil palm plantation in North Sumatra, there were acts of subjugation and silencing of movement targeting women's body. So at least from 2003-2017, there are 40 cases that under the research of Komnas Perempuan. So if we look at from the research of Komnas Perempuan, the metric of impact from the conflict of natural resources. For example, the physical violence, there are many bad things that experienced by victim. For example, beaten, a grab, kick, a punch, hand stabbing, and many things about the physical violence, and also about psychological violence, kill, and also there are accused as do not know about custom or adat, and threaten that they be beaten and tortured if they did not testify as requested by the police, threatened to be arrested and imprisoned, threatened to be killed, and so on and so on. So there are psychological violences that experienced by victims, and also sexual violence, harassed by poking poop and so on. Her body was grabbed and raped, and also used sexual gratification by company and so on. And the last impact is economic violence. For example, the wife whose husband died due to conflict due to the burden of family life, reduced and lost family income due to reduced loss of sources of life, and river or sea pollution, and also mining activities. This impact that research conducted by Komnas Perempuan. Gender-based violence against women in post-conflict situation. Komnas Perempuan observed that although the state has tried to support victims of past human rights violations, there are some practices of women marginalization, For example, the compensation mechanism prioritize men mostly, and also in aid program, women are not seen directly as victim and often associated with the husband as head of the family. Traumatized women victims receive double victimization and neglect. No single reintegration program involving women combatant in the context of social conflict, for example, and since reintegration of men combatant is prioritized. In the context of conflict, women keep experience violence, including agrarian conflict, with very little protection. The agrarian reform is still lacking with gender perspective and more investment-oriented that lead to massive land grabs. In Makassar, for example, in South Sulawesi and Palembang, the government involved in expropriating community land indicated by the involvement of PT Perkebunan Nusantara, state-owned BUMN, that says community land for large-scale plantation and lead the elimination of women livelihood resources. Recommendation, comprehensive and valid data regarding victim and perpetrator in various conflict is needed, and also regarding the protection of women in situation conflict, the presidential only issue presidential regulation, number 18, 2014, on the protection and empowerment of women and child in social conflict, or P3AKS. However, the implementation of the policy has not been optimal, so that it does not solve the problem experienced by women due to gender inequality and in agrarian conflict. The regulation also has not touched the root causes of the agrarian conflict, which has so far affected women, including indigenous women and children. Other recommendation, the Indonesian government to recognize the existence of women human rights defenders and their significant contribution and accommodate their interest in policy as a form of affirmative action. And also another recommendation, it is important for the government to issue a special and comprehensive policy on protection of women human rights defenders, since many cases of intimidation and violence experienced by them. Women women rights defender from community managed service provider institution actually work without budget, and personal protection equipment support. So government must pay attention more on women human rights defender. Last recommendation, policies instrument that guarantee the protection of women in situation of agrarian conflict is very, very important. Okay, I think that's my presentation today. Have a fruitful conference. I hope we can discuss in more detail. Thank you very much.
Thank you very much, Ibu Limatul, for this extremely comprehensive presentation, which has really walked us through a refresher of the key points of what the guiding principles and also other international standards says, including the very important provisions, of course, and principles linked to CEDAW, but also equally importantly for having really helped us identifying the spotlights of what the key issues are in relation to the work of women human rights defenders, and the other side of the coin being the specific challenges and discrimination faced by women, which are also the underlying challenges faced by women human rights defenders, and the need, as you mentioned in your last concrete recommendation, for women human rights defenders to be recognized in their own role. And the risks and challenges they face, which can amount all the way up to risking their own life, as we sadly know. And you also walk us through the specific challenges also faced by some specific groups, being indigenous women, or also the challenges faced by children. So we really have a lot of food for thought to take with us from this first intervention. And now I think we can move ahead with the second one, which will expand further on the topic of this session. And I'm again equally delighted to give the floor to Commissioner Sandra Moniaga from KOMNAS HAM, the National Human Rights Commission of the Republic of Indonesia, who's we have in front of us a very brief, succinct summary of their great achievements so far, and we really look forward to listening to your thoughts and reflections. And the specific topic which you will be help us unpacking is health access and government protection to equalize the right to health and corporate investment, and to support the efforts of human rights defenders in the health sector. And of course, of all times when we could have discussed this topic, with the ongoing COVID-19 pandemic, which is sadly witnessing a dramatic surge in Indonesia, as well as in a number of countries in the region, this focus and this discussion is going to be extremely critical and helpful. So I'm delighted to give the floor over to you, Sandra, and we look forward to listening to your reflections.
Thank you, Ms. Katia. Good afternoon, everybody. My dear Madam Katia Chirizzi, my colleague, Mbak Alimatul, and also the previous speakers, Commissioner Cadiz, and Mas Eko, Pak Eko, also moderator, Ms. Sagita, and the host, Dean Leona, Ibu Ida, Pak John, all of the organizing committee from the students and distinguished participants of the 4th Parahyangan Legal Competition 2020. I'm very happy to be here. I am jealous. During my student time, we didn't have this Parahyangan Legal Competition. So it is so nice to be involved in this very interesting session, meeting all the bright young law students and also bright high school students. Hello, Tiara. Hello, everybody. So, Ms. Katia, allow me to focus with this health issue. As you mentioned, it is the pandemic COVID, definitely. And also, at the same time, KOMNAS conducted a survey on the public perception about health service, which is relevant to be shared here. And we also finalized the standard of norms and regulatory, which also mentioned by Pa Eko in the earlier presentation. And actually, we are finishing also the standard norm and regulatory of human rights defenders, which I will share a little bit. So allow me to share the screen. So, in this very stressful and sad situation, I should make a presentation that is more optimistic, because otherwise we will all be overburdened with the sadness and frustration. So my presentation titled is Toward Fulfillment, the right to the highest attainable standard of health in Indonesia. I would like to start with Pancasila. It was mentioned, elaborated by Chair Taufan this morning. And I would just took 2 of the 5 principles, which is a just and civilized humanity and social justice for all Indonesians. So from the beginning, the founder women and founder, mother, and fathers of Indonesia already stated the importance to have social justice for all Indonesian people and a just and civilized humanity. So I think it is very interesting to look again to these principles in this situation. Secondly, the Republic of Indonesia Constitution adopted human rights principles in 2000 in the Second Amendment, which include Article 28H.1, which stated that every person shall have the right to live in physical and spiritual prosperity, to have a home and to enjoy a good and healthy environment, and shall have the right to obtain medical services. So if medical service is a constitutional right. And the last one, I would like to look at the right to health is the right to the enjoyment of the highest attainable standard of physical and mental health. The UN Committee on Economic, Social, and Cultural Rights has stated that health is a fundamental human right, indispensable for the exercise of other human rights. We can't work, we can't enjoy other things when we are not healthy. So my presentation will include, the first one will be introduction, and second is about the realities, and the third will be the human rights standards of norms and regulatory, and the fourth will be the conclusion. So let me start with the introduction. In 2017, I think Madam Katia was already in Bangkok. Indonesia enjoyed the visit of UN Special Rapporteur for Right to Health, Dr. Dainius Puras. And in his back to office report, the first statement was Indonesia is on the right track to develop an equitable and sustainable healthcare system based on universal health coverage. And at the end of his first official visit, it was released to the media. However, he warned, ambitious goals can be reached only if challenges are addressed. So this is a message, important message, and I hope you will have the chance to look the complete statement in the UN website. The other things, we recognize private sectors have important roles in health issues, ranging from providing health services, producing medical goods, and also trading. So it's a wide range. The other issues that we realize that human rights defenders have a positive, important, and legitimate role, contributing to the realization of all human rights at all local, national, regional, and international level. They have been engaging with government and contributing to the effort in implementation of the obligation and commitment of the states. However, the current condition of COVID-19 pandemic indicates that there is a very extraordinary health emergency situation. So extraordinary measures are needed and this shown from the trend of spread of COVID continuing to increase in Indonesia, especially after the detection of new variants such as Delta. As of July 22, yesterday, based on the data from government COVID-19 Handling Committee and National Economic Recovery, there were 2 million, more than 2 million, almost 3 million positive confirmed cases, 549,000 active cases, 2,356,000 recovered, and 77,583 dead. The number of health workers who died reached 1,439. Capacity of hospital was getting fuller, so that it had impact on getting access to health services. The availability of medicines needed for COVID-19 sufferer is not evenly distributed and accessible. And according to the Indonesian Pediatric Association, at the end of June 2021, child mortality due to COVID-19 in Indonesia had become the highest in the world. And even Indonesia had become the #1 country in the world for daily positive cases of COVID-19 and the second highest number of them. So this is the reality we have. And challenges for fulfillment the right to health shall be based on 5 principles according to the international standard. The first is on affordability, availability, accessibility, acceptability, and quality. So allow me to share the realities of the right to health situation based on the result of a survey of public views on the right to health in the national health security system in Indonesia. The survey was conducted in 2020 in cooperation with Litbang Kompas, which is the research and development of Kompas Daily newspaper. So it is a reputable survey institution. The first aspect is about awareness and affordability. Indonesian people in general understand the right to health is human right, and the government is duty bearer to fulfill the right to health. Regionally, people in the western part of Indonesia are more likely to entrust health services to the government. In terms of education, confirming that the higher the education, the knowledge and demands that the government bears on the obligation to fulfill the right to health will be. But that means they also understand and perceive that there are people who also think private sector is also health service provider. The obligation to pay monthly fee of BPJS or Social Security Administrator is considered a burden for some communities such as low income, people with disability, and layoff victims. The social economic condition of community affect the health service received by community. The issues of healthcare administration ignore the essence of health as a human right. So this is the situation that administrative procedure become the burden and become or ignore the essence of health as a human right. During COVID-19 pandemic, many workers were laid off. This had implications for the BPJS contribution that were in arrear or stopped due to no income. Therefore, enjoyment of health service as human right will also be disrupted, reduced, or not maximized. The problem of people who do not know how to register to BPJS health services is also one of the important points that need to be considered by implementing the national social security system in Indonesia. Government is obliged to guarantee the right to accurate and fast information for all people regarding health service. In this case, the government, the responsibility of implementing national social security system need to pay attention to and consider the social economic aspect of the community so that everyone can continue to enjoy the right to health services properly. The other aspect is about accessibility. The survey was conducted all over the country, in all provinces, with region from cities to the suburb. In the context of right to health as human right, the administration of BPJS services actually reduces or hinders everyone from getting health service. The right to health is a human right. However, right to health is contextualized in BPJS services. It should not ignore vulnerable groups or groups of people with low economic income. Emphasize that BPJS administers everyone's right to health, so it should not be an obstacle to the fulfillment of the other right. Okay, acceptability. Regarding the participants of penerima bantuan iuran or recipients of contribution assistance, this is a government program. 60%, 61% of the respondents stated that they were not on target. This means there is a need for fundamental improvement related to the selection mechanism and provision of contribution assistance to the community in the service of right to health. Contribution assistance recipients should be the poor and needy people participating in the social security program whose contributions are paid by government according to provision of law number 40 of 2004 concerning national social security system. So we have several government regulation that support this service. Right to health is a human right, which the government has the responsible to fulfill, respect, and protect. BPJS is an institution formed to administer health insurance program in Indonesia. However, with the obligation to pay BPJS contribution, it makes health seems like an obligation, even though health is a human right. The issue of health right is that human rights are a problem in BPJS system, because they view that the right to health is only limited to administration. The third aspect about accessibility. Regarding access to health facilities, although 72.4% of respondents stated that it was easy to reach health facilities because most of the respondents are in the cities and suburbs. However, 19.8% of respondents stated that health facilities were not easily accessible. This is related to accessibility to community, to the existing health services, especially for vulnerable group. Accessibility here that needs to be considered is about transportation and transportation costs to reach health facilities. Assistance for disabled, the elderly, and children and other vulnerable groups, so that the enjoyment of health service can be maximized and not discriminatory. Lastly, about the quality and availability. In terms of quality of doctors, they are considered good, but there are still those who state that they are not good, still need to be improved. The availability and quality of drugs and equipment is still a problem, so the quality and availability must continue to be improved. The availability of health workers is still very inadequate in central and eastern Indonesia. This shows that there are still disparities in the right of citizens to get health service. Lastly is about discrimination. As many as 55.8% respondents stated that the limited health facilities receiving BPJS help patients and complicated procedures. This is the complaint that is most often heard by respondents in BPJS health service today. This shows that community needs more health service than that can accept BPJS. So there are some places do not accept BPJS, especially the private hospital. And 19.8 respondents who experienced treatment discrimination or discrimination in obtaining BPJS services. We also look at the situation of people with disability or person with disability. The fact that the right to information on health service for person with disability is still not fulfilled significantly. 85% do not know about it. The state has not fulfilled its obligation to fulfill the right to information for persons with disabilities and their families. The state is obliged to provide more protection for people with disabilities who are entitled to receive BPJS, especially in Eastern and Central Indonesia. So that is the result of the survey that I share. And I'm stepping to the issues of human rights defenders. KOMNAS HAM focus on the issue of human rights defenders. For the year of 2020, we found there are violation, threats, and attacks against human rights defenders. There were at least 11 cases that reported to Komnas HAM. And in 2012, we also published a report. At that time, there was also around 11 incidents of violation or attacks against human rights defenders, include slander, unlawful of legal process, suppression of unions, assault or physical violence, dismantlement of activities, and shootings. Now, in regard to health right defenders, I am lucky that I could interview the coordinator of Lapor COVID. Lapor COVID is citizen coalition to report COVID-19. It formed by a group of individuals who are concerned about citizen human rights and public health issues related to the COVID-19 pandemic. This coalition was formed in early March 2020 when cases of COVID-19 broke out and were officially discovered. The link to this Lapor COVID is here. So up to now, they found there are threats experienced by Lapor COVID. 2 volunteers received intimidation from staff or head of service from the local government after Lapor COVID team helped reported a number of health workers in the particular district to disburse the incentive. In one area, 45 health workers have not received incentive since October 2020. And they also assist healthcare network, Indonesian Healthcare Network, who is alliance of doctors and other healthcare workers who hasn't received their payment also, incentive since November 2020. And they work together with Legal Aid Foundation and Legal Aid Foundation Jakarta and Indonesia because the problem is spread out all over the country. The last threat they found also from staff of one of the minister in Jakarta when they published in social media about the death toll, the different number. And they were asked, so they came to the office and explained why the number is different. They explained that the number is came out from the data from the provinces. So the data is calculated and the person at the minister have a different number. And they feel threatened at that time. And those volunteers who are threatened are women. So it happened. So after sharing the situation, and now I would like to share about the human rights standard of norms and regulatory or standard norma pengaturan that prepared by Komnas HAM. We have already produced 5 of this SNP and in the process of finalizing the last 2 and in beginning another 2. So there will be 9 at the end of this year. So standard of norms and regulatory is a breakthrough initiative of Komnas HAM in the absence of solid interpretation of specific human rights issues in Indonesia. Komnas HAM has been drafting the SNP since 2018 with full support from the government of Indonesia, particularly the Ministry of National Planning. Standard norm and regulatory is aimed to provide interpretation, assessment, and guidance on human rights principles in particular specific rights or issues or subjects. For example, we have freedom of expression, we have right to health, we have also on the elimination of racial, ethnic, and religious discrimination. The SNP is aimed to promote human rights norm based on international human rights principles and standards, and it applying universal principles into the national context. Human rights norms can be operationalized according to international human rights standards and principles which taking the particular traits of Indonesian context into account. I think Pak Eko explained more detail earlier this afternoon. So about right to health. Health is a fundamental human right, indispensable for the exercise of other human rights. Every human being is entitled to the enjoyment of the highest attainable standard of health, conducive to living a life in dignity. The right to health in all its forms and at all levels contains the following interrelated and essential elements, the precise application of which will depend on the condition prevailing in particular state party. So health as a state complete physical, mental, and social well-being, and not merely absence of disease or infirmity. So these are the main things. The core obligation on right to health is here. It's on our paragraph 66 of the SNP. We can, I think it mentioned also earlier by Pak Eko. And second is about the SNP on human rights defenders. We focus on this human rights defender, as I explained earlier, because of their strategic role in this promotion and protection of human rights. Human rights defender is a term used to describe people who, individually or with others, act to promote or protect human rights. Everyone, whether individually, in a group, or in organization, has the right to promote human rights. This right provides a role of the community to assist the government in carrying out its obligation in the field of human rights. Individuals, group, or organization that play a role in effort to protect, fulfill, and respect human rights. So there are several descriptions of human rights. Human rights defenders have the right to physical, social, economic, and psychological health, physical and psychological recovery, welfare, the opportunity to live in family, colleagues, and the environment. The guarantee is given by taking into account the condition and capabilities of the organization or institution of the particular human rights defenders. So there are interrelated provisions of these SNP of right to health and human rights defender. We realize that their affirmative actions aim to protect the enjoyment of the rights for vulnerable and marginalized or minority group is not a form of discrimination. The three main principles of right to health: non-discrimination, human dignity, and state responsibility. So the human rights defenders also have the right to health. So there are things that we can see here. States should respect, protect, facilitate, and promote the activities of human rights defenders and other members of civil society in order to assist vulnerable or marginalized groups to enjoy right to health. So now I come to the conclusion and recommendation. As I mentioned earlier, Special Rapporteur for Right to Health identified and stated clearly that government of Republic of Indonesia is on the right track toward realization of the right to highest attainable standard of health in Indonesia. However, there are various challenges that need to address comprehensively to ensure the affordability, availability, accessibility, acceptability, and quality of the realization of right to health. Although majority of Indonesia entrusts health service to the government, however, there are many Indonesians consider the important role of private sector as well. Thus, the role of private sector in health services shall further develop. Human rights defenders is important in promotion and protection human rights. However, their assistance is not fully recognized and protected in Indonesian legal system, as mentioned by Ibu Alimatul. Right to health defenders do exist and facing various threats. The information from Lapor COVID is evidence. They need to be supported and protected. Komnas HAM produced already standard of norms and regulatory, including on right to health and human rights defenders. This instrument recognized by the Ministry of National Planning and appreciated by many parties. So I recommend that it's important for all parties, state, private sector, academic, press, and all people, including students, to work together to develop a strong coalition to promote right to health condition, particularly to halt the pandemic COVID-19 and to achieve the highest attainable standard right to health in Indonesia. It is important to consider Komnas HAM SNP, sorry for self-promotion, on the right to health as elaborated translation of the highest attainable standard of right to health, which shall be referred by the government of Indonesia, private sectors, and other parties. It is necessary for a government to guarantee the protection of all rights, all human rights defenders, including right to health defenders, and promote policies for protecting and promoting their rights. Government need to speed up the process in preparing National Action Plan of Business and Human Rights, which include issues on the right to health and human rights defenders. So I will end my presentation by stating that if we do develop the highest attainable standard right to health and we protect human rights defenders, I think we are in line with
Halo, Mbak Sandra freeze ya?
There must be a connection issue at Ibu Sandra's end, I understand. Shall we then maybe waiting for Ibu Sandra's connection to get resolved? I see there are already a couple of questions which have been asked in the chat box, and that's great. And I would encourage all the friends participating to include more, anything you might want to ask to our two panelists. And maybe I could start by asking the first question, which we have received for Ibu Alimatul, and then taken from there. So a first question is from Tiara, who would like to ask Ibu Alimatul, how can we, as the younger generation, establish good business environments that could protect gender equality in Indonesia? Because there's a lot of the working areas that are gender specified, and most of the time, men are considered more qualified in running a business than women. What can we do to combat this issue? So, which is a very, very important question. So, over to you, Ibu Alimatul, for the answer.
Thank you, Ibu Katie. There are two questions for me. First, how to be young entrepreneurs have or establish good business, yeah. And the second one, how to combat the gender bias among society, yeah, in the business area. Okay, for the first answer relating to how to be best business person, with accommodate the gender equality perspective, we have to understand the practical and strategical needs of women. What means by practical needs of women? Women has different different tasks relating to the reproductive tasks, such as getting period, menstruation, and also giving birth, and might be breastfeeding. So we have to understand that need related to women's practical needs, yeah, because sometimes if there is no perspective about practical women's need, there are many problems that faced by women when working in that area. And this still happen in Indonesia. For example, as you know, in the 5-star hotels, they don't provide the napkin of women, but they provide for something. What is for the cutting? I don't know how to call it in English. Yeah, pencukur jenggot.
Shaving kits.
Yeah, shaving kits. Yeah, you know that if we getting period, we can't stop. But if we have a shaving here, it's no problem. We can delay until tomorrow. But if we look at the kids in the 5-star hotels, still they don't have any practical women's need perspective. So if you want to be best, business person, you have to consider and also fulfill the right of women relating to the practical needs, because we still have faced this problem. And second one, relating to strategical needs, which is how to provide, the equality services and also the equal belief, from our thought, from the beginning, you have to believe that men and women have the equal rights, have equal performance. And you know, in Indonesia right now, I think also in many countries, the best student in graduation right now mostly female. Yeah, mostly female. I used to be as the vice dean in my university for 6 years, and for me it's difficult to find the best student for male. What does it mean by this kind of situation? It means that the opportunity for women to do best, is more open right now. But then, related to the second question, sometimes we can't do more when we were at workplace, because of maybe the breadwinner responsibility not goes to the women, or maybe there's still a gender stereotype bias in the society that women cannot be a leader, and so on and so on. So what we can do if we face this kind of situation, maybe we can use the constitutional law, that Indonesian constitutional law guarantee that cannot discriminate against gender, using the constitutional law. And second one, if maybe you can also use this kind of perspective if you are a religious person, and depend on who we are going to talk, maybe you can also using the normative religious standard, which promote equal interpretation, and also the third one, we have to say in assertive communication. Assertive communication means we can say what our feeling, but without any aggressive behavior or aggressive attitude toward the person who has this kind of policies. And also do the best for yourself, because if we can do the best for ourselves, so we can maximal in our performance, and people will looking for us, not we looking for the job, but they will looking for us, either we men or women. I think that's my response. Thank you.
Thank you very much, Ibu Limatul, and I can see now that Ibu Sandra could reconnect, which is great. And well, had you completed your presentation at the time we were disconnected, or you had some final thoughts you could not?
I don't know. Was it up to the recommendation, or was it?
Yes, it was towards the very end tail. Yes,
I'm finished.
Okay, but then let me take the opportunity to really thank you for that extremely comprehensive presentation, and in particular for the very strong human rights-based approach that you have adopted, really helping us unpacking what does it mean, the right to highest standard of health, so what it means in terms of all the elements that you have provided, but also what does it mean in terms of the affected groups and communities, in particular the specific challenges faced by persons with disabilities, and also congratulating KOMNAS HAM for the great initiative of the SMPs, which is again an extremely important tool, bringing us back to what the international human rights standards and principles are about in relation to the right to health and how they need to be adopted when addressing equal access to health in law and practice, so that no one can truly be left behind. So thank you very much for that. I see we have a number of questions coming in, which is great. And we have just asked the first one to Ibu Limatul when you were disconnected, but there is one addressed to you, Ibu Sandra, which has to do actually two similar questions, which go to the point of those citizens who, while having access to vaccines, refuse to get vaccinated. And the question is, are there actions within their human rights in the current situation, as their behavior can be potentially endanger the health and safety of others? So what are your thoughts in relation to this question? Over to you.
Thank you, Ms. Katia. Thanks for very good questions. What we encourage is the government to actively promote and educate the people about the importance of vaccines, and at the same time provide more access, because as you know, there are so many people who want to be vaccinated, but they cannot do that. And there are people who do not want to do that because of some reasons, but we keep coordinating with the government and also religious institutions about these issues. It's not only the government. And we also encourage the government to outreach more influential people. At the same time, we also criticize the negative campaigns like bullying, like negative things. I think the important at this time is to bring positive spirit, to this work. So to some extent, we still think that vaccinated is part of right to health. This is what we think. And the right to health, not just for the person, but to other people. Because once you are affected, you are also infectious to the others. So unless you live alone in an island without any interaction, without any social life, you are free to do that. But if you live with other people, then we need to take care of other people's rights as well.
Thank you very much for sharing these thoughts. And just to mention that I think this is an issue which is being faced by all countries in the world. So it's not unique to Indonesia. So it's a question that many others are grappling with right now. But thanks for sharing your thoughts on that. I will then move forward to the next question, which is asked to both of you. It comes from Dila, and it mentions, recently there have been many poor people who have not have access to health services, and they do not get the Health Indonesian card, yet they also have no ability to afford the health service. What is the role of the government to safeguard the rights to health for the people, and how the national commissions in Indonesia can stand by their interests? So over to you both. Maybe Ibu Limatul, would you like to start? And then we move to Ibu Sandra.
Okay, thank you very much for that question. For the poor people who do not get access for the health right, what the government should do and what the national human rights institution can do. Yeah, I think the government has already done many program relating to fulfill the health right, although the implementation still need to be criticized and also need to be examined, yeah, because sometimes there are many cases that the data that collected by the government is not match with the reality from the society, and also relating to the what the Komnas Perempuan, for example, can do about this kind of issue, because one of the tasks that Komnas Perempuan have is to review the regulation and also to report, yeah, and give recommendation to the government. So relating to women issues, for example, that related to the reproductive tasks in some health issues, we focus on that kind of issues, which is, for example, during the pandemic era, in the early period at that time, there are many women who were pregnant get difficulty to access of health, because suddenly the hospital and also clinic services they only focus on COVID victim, for example. So we try to discuss with the government, not then stop, yeah, the services relating to the women's reproductive health. And sometimes this also relate to the poor people who also doesn't have any access of the health services. So first, we have to make sure that the data that they use by the government is the right data. So in the reality, in the community, people who do not have any access for the health right is need to be paid attention.
Thank you very much. Over to you, Ibu Sandra.
Thank you, Ibu Katia. As I shared earlier, first of all, the role of Komnas HAM is an auxiliary body. So as an auxiliary body, we are different with government. We are not the executing agency. And what we do is, for example, we did the survey to get a more broader and objective picture of right to health in Indonesia, and that we shared with the government. Secondly, we developed the SNP, as I also mentioned earlier. We also make direct recommendation. For example, on this pandemic COVID, we already made recommendation in March 2020. We also made recommendation to the president in August 2020, and we just released another one today, just now. So that is a kind of work. At the same time, we also try to keep the dialogue with the government. In the other hand, we also coordinate with the other institution, with some civil society organization in promoting the human rights situation. We also become the bridge for some mediation process, like some complaint related to right to health. So we mediate with the hospital or with the government. So there are several things we conduct based on the authority we have according to the law number 39 of 1999. So that is how we work. We also work together with Madam Katia's office, for example, when there were visits of the special rapporteur and also high commissioners and other. So those are the things we conduct. I hope it helps. Thank you.
Thank you indeed, and thank you for the very practical illustrations on both sides in terms of what is the role of your respective commissions. I will move to another question, which is again addressed to both of you, and which is looking in particular at the impact of COVID-19 on workers' rights, and looking at how a number of employers are threatening to cut wages and other entitlements such as holidays, and how in some sectors, despite not running essential services, their physical presence is required. And so the question is, how should the government make the balance between the right to health and the right to have proper income and working security, which in the current pandemic context seems to be sometimes at odds with each other. So highly welcoming your comments on this. Back to you, Ibu Limatu.
Okay. I think this is not the war. Yeah, we can perceive the war between economic and also health issue. But we have to balance the economic and the health issue. And I know that is very difficult, because the society is very diverse relating to the economic situation. For example, according to the survey that released by LSE a few days ago, that the economic impact faced by 70% of Indonesian community, Indonesian society. So that's why I think all of us, we have to be patient and also try to think creatively to survive, because we know that the government is already work a lot, although again, there are still lack of services, for example, because like the Komnas Perempuan survey, the community, they go to the non-government services more than the government services, because like the government services, they don't open 24 hours, but the community need time to go to the health service, or including the sexual violence services, is sometimes is not in the work time, but outside the work time. So that's why the government also have to pay attention to the non-government social services, including the one that they also deal with the sexual violence, for example. So I know this is not satisfied answer, because it's difficult to make balance between the economic and also health issue in this pandemic era. But the thing that we can't say that it is the war between the two, but we have to integrate the two things with the balanced perspective. I think that's all, Kathy. Sorry if it's not satisfied answer, maybe.
Question. No, of course, that's great. Thank you very much. Over to you, Ibu Sandra.
Well, Komnas HAM on the states also think the importance of balance. However, we think right to live is fundamental rights, and we have to prioritize on the right to live of all persons. And in this pandemic, there is no compromise. We have to prioritize on the right, on the life of every individual, including the health workers. So I think economic recovery and other can be done. It's all human made, but life, you cannot reinvent when somebody already died. Thank you.
Thank you very much to both of you. Really, this has been such an enriching discussion, and against a backdrop which is really sobering and the compelling figures that we have heard about the number of COVID-19 cases right now in Indonesia. I think it's it made this discussion all the more relevant, considering how much there is at stake. I would not try to summarize, because it would be mission impossible, all the very good points which have been raised, but I hope it is okay to use my prerogative as the moderator to share the last minute I have, using 30 seconds and giving those 30 seconds back to each of you for any final keywords and messages you would like to share. And going back to where we started from, which is also the role and the challenges of women human rights defenders and of human rights defenders, in particular in the context of COVID-19. So back over to you, Ibu Limatul, for a few 30 seconds, final 30 seconds of your reflection.
Okay, thank you very much, Ibu Kati. However, please let me respond a little bit about the last question about the polygamy. My position, I don't agree, because Islam, what I believe is the basic principle of marriage is monogamy, not polygamy. So I don't agree with that. Okay, and then for the closing remark, relating to the women human rights defender has a lot of problem, including during the pandemic, that still there is a negative stigma for them, which is like against the government, and also just create problems, not solve the problem. So we have to face this kind of situation. And the second one, relating to the agrarian conflict, which is a lot of women also involved to this kind of protection from their land, from their right to the forestry and so on. So also, according to the Komnas Perempuan research, there are many negative impact that faced by the victim relating to the agrarian conflict, in particular for women. I think that's my conclusion. Thank you.
Thank you so much, Ibu Limatul. Over to you, Ibu Sandra.
Thank you, Ms. Katia. Again, thank you so much for this opportunity. I would like to re-emphasize on the importance to develop a strong cooperation of all parties to work together to really seriously look at this pandemic, COVID pandemic, and also right to health as a fundamental rights of each person. Without health, you can't enjoy other rights. So let's work together and make sure that the government, the corporations, and other party respects our right in the highest standard. Without the highest standard, we can't enjoy right to health, and we cannot have enjoy the other right. Again, thank you, and I hope this legal competition will be fun and enjoyable by all participants. And thanks again for a very interesting webinar today to Ibu Katia and all colleagues. Thank you.
Thank you very much. And again, it has been a privilege to moderate this discussion, and just to reiterate that our office looks forward to continuing this engagement and discussion with you all, which is absolutely critical, even all the more during this specific pandemic times. So thank you very much. And then back over to the giving my floor to the organizer. Thank you very much.
Thank you very much, Ibu Kathy. Thank you very much.
Thank you so much.
Makasih Mbak Limatul.
Makasih Mbak Sandra.
A very inspiring webinar and very useful for all of us. We hope that the material that has been presented will be useful for all of us in the present day. Thank you so much, Ms. Katia Chirizzi, for moderating this afternoon session. This session will also close today's webinar. Thank you so much to all participants that have participated in today's webinar session.
We would also like to remind all participants to fill in the re-registration forms that have been announced by the committee through WhatsApp groups and the Zoom chat. This is required for all participants, as we will need the data to hand out certificates of participation for our guests that have tuned in to the webinar.
Ladies and gentlemen, next we will hold a photo session together. We would like to kindly remind you that all participants must activate their camera.
Once again, we would like to kindly remind you that all participants must activate their cameras.
Since most of the participants have already turned on their camera, we will leave it to the Publication and Documentation Division.
We will now proceed to a webinar documentation session. There are currently 11 pages. There are currently 11 pages of participants in the Zoom meeting, and we will start from the first page. 3, 2, 1. Page 2, 3, 2, 1. Page 3, 3, 2, 1. Page 4, 3, 2, 1. Page 5, 3, 2, 1. Page 6, 3, 2, 1. Page 7, 3, 2, 1. Page 8, 3, 2, 1. Page 9, 3, 2, 1. Page 10, 3, 2, 1. Last page, 3, 2, 1. Thank you everyone for your participation.
Thank you very much everyone for your participation.
Before we head to the next session, we would like to thank our co-hosts, Office of the United Nations High Commissioner for Human Rights and the National Commission on Human Rights of Indonesia.
Also, we want to say thank you to our media partners, Ardan Radio, Hukum Online, and Berita Satu, that already helped provide information regarding the Parahyangan Legal Competition 2021 to all participants that have attended here.
In addition, we would like to express our deepest gratitude to Anan Kelana Haryanto and Hermanto Loven, Angranian Partners, and Nutrifood Indonesia Limited Liability Company for being our sponsors in Parahyangan Legal Competition 2021.
We will again like to inform you about the promotion from our sponsor, Nutrifood Limited Liability Company. They would like to give away vouchers that give 30,000 rupiah off to the first 300 of our participants that shop for a minimum of 200,000 rupiah in nutrimart.co.id by using the code NHUBJabar. And for further information, please contact Dery in WhatsApp number 085798483828.
Furthermore, to all participants that have attended the Zoom meeting are able to find practical legal reference in premium stories that present reviews of important issue, doctrines, jurisprudence, and court decision in one comprehensive article by subscribing for a price of 42,000 rupiah per month at hukumonline.com/stories.
Thank you to the speakers, moderators, and all participants that have participated in this webinar so that it was able to run smoothly. Hopefully, the topics discussed have been meaningful to everyone. For the sharing of the PowerPoint materials and the handing out of certificates, it will be informed through the WhatsApp group. For all speakers and moderators, you will be directed to the breakout room, while the rest of the participants of this meeting are allowed to leave the Zoom meeting.
Maka, telah berakhirnya sesi webinar juga menunjukkan bahwa opening ceremony Parahyangan Legal Competition 2021 akan segera berakhir. Karena kita memulai acara pada hari ini dengan doa, maka sebaiknya kita mengakhiri acara ini dengan doa juga.
The end of the webinar session also shows that the 2021 Parahyangan Legal Competition opening ceremony will end soon. Because we started today's event with a prayer, we should also end this event with another prayer.
Untuk pembacaan doa penutup akan dibacakan oleh Geraldo Adrian Stanis.
The prayer will again be led by Geraldo Adrian Stanis.
Kepada Geraldo, kami persilahkan.
Good evening, ladies and gentlemen. Let us end today's session with a prayer. I will be leading in Catholic prayer. For those of other religions, please pray according to your respective religions and beliefs. Let us pray in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Lord God, you could not do wrong in your providence. Thank you for your guidance and blessing throughout the day as we were all able to finish today's activities. Father, tomorrow we will continue the competition. Grant the delegates your Holy Spirit so they can bring out their best from their preparation. Grant the judges Holy Spirit, grant them the knowledge of faith, as they can continue to give assessment in accordance with the knowledge they have. Grant the committees your Holy Spirit so they can do their job precisely in order for the competition will run in accordance to your will. Father, this is our prayer to you, through Christ our Lord, because only you are the King of glory and power forever and ever. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
Terima kasih banyak kepada Saudara Geraldo. Lalu, kepada Ketua Delegasi dari Lomba Debat Tingkat Sekolah Menengah Atas dan Lomba Debat Tingkat Universitas, juga kepada delegasi dari Lomba Karya Tulis Ilmiah, kami persilakan untuk mengikuti technical meeting dan tetap tinggal di ruangan Zoom ini.
To the delegation heads of the Scientific Writing Contest, the High School Debate Competition, and the University Debate Competition who will attend the technical meeting, we invite you to stay in the Zoom room.
Demikian dari kami selaku Master of Ceremony dalam acara dalam acara Opening Ceremony Parahyangan Legal Competition 2021. Saya Tiara, dan rekan saya Daryl, kami pamit undur diri. Wassalamualaikum warahmatullahi wabarakatuh. Om Shanti 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 Om. Namo Buddhaya, salam kebajikan, dan sampai berjumpa kembali.
Thus, from us as Masters of Ceremony at the Parahyangan Legal Competition, goodbye and see you again.
Technical meeting akan kami serahkan kepada panitia yang bersangkutan. Dan kepada para peserta yang tidak memiliki kepentingan apapun lagi, kami persilahkan untuk meninggalkan ruangan Zoom ini. Terima kasih. Selamat sore. Perkenalkan, nama saya Sarah Abista, selaku Koordinator Divisi Teknis Debat Universitas. Mohon perhatian, saya ingin menginformasikan sekali lagi bahwa sesi selanjutnya adalah technical meeting. Kepada perwakilan, delegasi universitas, sekolah menengah atas, dan lomba karya tulis ilmiah, dipersilahkan untuk tetap berada di ruangan, dan selanjutnya akan diarahkan oleh panitia untuk memasuki ruangan technical meeting. Selain itu, kepada delegasi lainnya, dipersilahkan untuk meninggalkan ruangan virtual Zoom. Terima kasih. Sekian yang dapat saya sampaikan.